is trying to run a monopoly here. He wants to be a speaker and an MC.
Black monopoly capital.
He's giving you airtime. You should be grateful. This was his slot originally. We must tell you.
We're live. We're live.
It's still my slot. What do you mean original?
Hi, Pakamisa. Okay, we're live. Everybody can hear us.
Okay.
Good morning, ladies and gentlemen. Good morning once again to the final day of our Competition Law, Economics and Policy Conference. It's been an amazing past 2 days. I'm not alone. I'm joined by my co-host, Mpumi. Mpumi, how are you doing?
Simpiwe, I'm grateful to be back. I had dreams last night. I had dreams about the content. And one of them was thinking about how we have reached a Pan-Africanist plateau, or let me say peak, Pan-Africanist peak with what we saw from the ACF and the kind of African cooperation that we have and the insights we learned about a regional competition policy on the continent. So honestly, I had dreams of African unity last night. That's how I am doing. I had dreams of Pan-African dreams coming true.
Yeah, and if you can see the lineup for today, you're really not mistaken, because I think it's just going to continue to fuel that energy and that fire within you. Ladies and gentlemen, you have no idea what we have in store for you today. This morning, we're going to have a talk by the advocate Thembeka Ngcukaitobi, a seasoned legal professional. He's an acting judge at the moment, but he's going to talk to us this morning about constitutionalism and access to healthcare in light of the Mediclinic judgment that was delivered just last week, Friday, by the Constitutional Court, as well as a fantastic book launch. It's an amazing book. It's garnered so much excitement and support by Pakamisa Nzamela. It's titled The Building Blocks of Black Business Class in South Africa. And it's going to be discussed by Advocate Thembeka Ngcukaitobi as well as Pakamisa Nzamela. That's just this morning alone. And so without any further ado, we've got a jam-packed session. We will keep you posted along the way. Just to indicate to the audience that there will be an opportunity towards the end of Advocate Ngcukaitobi's talk to be able to engage and have a Q&A session. And so as we have been doing throughout the course of the conference, please use the Q&A function in the platform to submit your questions, and we will then appropriately direct them to the advocate, or perhaps to Pakamisa if that is to whom you wish to direct your question. But without any further ado, I will hand over to Advocate Ngcukaitobi to kindly address us on constitutionalism and access to healthcare in light of the Mediclinic judgment. Advocate Ngcukaitobi, over to you.
Thank you very much for the invitation, and thank you for the opportunity to speak. I am obviously very excited to be here and to be talking among colleagues and friends and people I hold in high regard. I had initially planned to talk broadly on the topic of constitutionalism and its implications for access to healthcare. My plans were disrupted in the light of a recent judgment, not my judgment, a judgment of the Constitutional Court by Chief Justice Mogoeng, which is literally fresh off the printers. And I thought it would be remiss not to consider its implications, because I think it has significant implications for a number of questions that I've personally been engaged on and discussing with the Commission and with the colleagues in the field, particularly on the question of what is the scope of constitutional control and regulation of market power as provided for in the competition legislation and policy. And the reason why that question is crucial is because we take for granted that the Constitution must regulate public power. It must regulate the conduct of politicians. We now also take for granted that the Constitution should regulate private power, the conduct of parties engaged in contractual arrangements. But we have not yet explored fully the extent to which it should also regulate market power. And this, for me, is a gap in our analysis and understanding of the full extent of constitutionalism and its implications. So I want to explore, at least through the lens of the Mediclinic judgment, what is the scope for this potential regulation? Of course, because it is a judgment, it's got technical facets, but these are very fascinating insights, even though they are technical, at least at two levels. The one is, to what degree should courts of appeal interfere with findings of fact and expert opinions, as well as remedial decisions taken by the competition tribunal? And the bulk of the judgment in Mediclinic, as I'm about to unpack, is on that question. And that has significant ramifications for future litigants inside the space. The other is, how should the tribunal itself assess the evidence that is presented in front of it? So I want to look at that issue, and hopefully I'll do this in 20 minutes, and hopefully we can then have 10 to 15 minutes time to discuss what issues arise from the Mediclinic judgment. So first, the context. What we know is that the market healthcare inquiry published its findings 3 years ago. One of them, it's actually interesting, was a finding that it criticized the Competition Commission's approach to measures in the healthcare sector. And it said it didn't fully address the high levels of concentration, and that its system of measure review is not effective enough, and it doesn't provide practitioner associations and guidance in relation to what constitutes pro-competitive conduct and the method that it uses for evaluating. And consequently, it places at risk access to healthcare. So that happens 3 years ago. What we also know is that on the constitutional side, we have a broad section, section 27, that provides for right of access to healthcare, right? And not only does it provide for right of access to healthcare, but it also imposes an obligation on the state to take reasonable measures within available resources towards the progressive realization of that right. But there's also another specific provision that talks about no one may be denied access to emergency healthcare. And the social and political context in which these rights operate is a context where public healthcare facilities, I mean, this was all laid bare in the market healthcare inquiry. Public health facilities are almost in a state of collapse. And all of those pressures are then pushed into the private healthcare space. And that creates now this duality in healthcare services, in which people that can afford medical insurance, which is covered by medical schemes, people that can afford medical insurance are receiving state-of-the-art access to healthcare services. And at the same time, people that cannot afford private healthcare insurance and have to depend on the state are receiving the type of healthcare that can be described perhaps as suboptimal. There are obviously good public hospitals, but overall, the picture is bleak in relation to the provision of access to healthcare services for people that do not have private healthcare insurance. So it's in this context then that major regulation becomes crucial. A further contextual factor is the amendments that came as a result of section 12 capital A 3A, that now particularly put the issue of public interest grounds as one of the grounds that have to be considered at the competitive and substantive assessment of whether to approve or refuse a merger. So to move quickly then along, what happens here on the facts, most of you would have seen the judgment or at least would have been familiar with it, is that the competition tribunal, the competition commission rather, prohibits, competition tribunal prohibits a merger using its powers under section 12 capital A 3A. What it finds that there are adverse effects of the merger in the sense that it will substantially the test, substantial lessening of competition. But it also finds that it's in the public interest to prohibit the merger of Mediclinic. And it says specifically, the proposed merger would have a significant effect on the healthcare costs of both insured and uninsured patients living in a specific region, in rural Potchefstroom-Klerksdorp region. And particularly in the light of the significantly lower tariffs of the hospital that Mediclinic wanted to acquire. And then it says, moreover, the uninsured patients in that area, this is the Matlosana area, who are a vulnerable group, these are Black poor people, and that's the context I tried to set out at the beginning, would have less choice of cheaper hospitals post the merger, and this would adversely affect their ability to switch between cheaper options. And the tribunal also emphasized that the robust common cause evidence was that the proposed merger would significantly increase the tariffs at the target hospital for both the insured and uninsured patient market segments. And it would thus, in the tribunal's view, lead to an adverse public interest effect with no countervailing positive public interest ground advanced to mitigate this. Now, I think for the first time, we get an explicit public interest reason for prohibiting a merger debated at the Constitutional Court. It's explicit, it's out there. What they say is there will be an increase or a probable increase in prices post the merger for poor, vulnerable people at the target hospital that Mediclinic wants to acquire. Now, of course, we know that the minority judgment, a judgment of Justice Teron, says, look, we should be very skeptical about this factual conclusion. But for the current purposes, let us take the majority's conclusions to be correct because I want to illustrate a broader point. So the first question that has to be decided, and this is what practitioners need to think about in relation to cases that will be going to the CAC and the competition and the Constitutional Court. The first question that the Constitutional Court has to think about is whether or not it should hear the case at all. Remember that what has happened is the tribunal prohibits the merger. On appeal before the Competition Appeal Court, they are overturned. Look, and I must say, the judgment of the Competition Appeal Court is monumental. I mean, it runs into more than 200 paragraphs. It is a monumental judgment by Justice Rogers. But he himself also acknowledges how significant the judgment of the Competition Tribunal is. So we are dealing here with a tribunal that has seriously considered the evidence before it, engaged in a serious analysis, but at the same time, we're dealing with the CAC that has also done the same. And so it's a monumental judgment. So the first question then is, in circumstances where the Competition Appeal Court has engaged in an anxious examination of the evidence before it on the record and engaged in a serious examination of the findings and the conclusions of the Competition Tribunal, on what basis should the Constitutional Court get involved? So this is the first reason why the Constitutional Court decided to get involved. It says the merger that is the subject matter of this litigation is in the healthcare sector. And the case is essentially about whether access to private healthcare services would be impeded, enhanced, or unaffected by the merger. It involves the interpretation, protection, and actualization of this constitutional right, and therefore implicates the constitutional right of access to healthcare services. So reason number one is because the sector is the provision of healthcare services, and the court has to decide whether or not the merger would impede, enhance, or neutral on access to healthcare services. And the way that access is defined is price increases. That's where the justification is. And then that's point number one. The second reason why the Constitutional Court got involved is it says the issues concerning competition in this particular economic sector, what the test or correct interpretative approach to Section 12 capital A is, and under what circumstances it would be appropriate for the Competition Appeal Court as an appellate court to interfere with and set aside the factual and policy findings, as well as the remedy of the tribunal, which is a trial court equivalent. So this is now the second reason. So the first point is it's because access to healthcare services are implicated. The second one is that it's because we want to decide the test for when the Competition Appeal Court may interfere with findings of fact, findings of policy, and remedial discretion of the competition tribunal. So how do they then go about doing this? Firstly, they debate the question of the ability of an appellate court like the Competition Appeal Court to interfere with the findings of fact made by the tribunal. This is what they say. They cite, in fact, incidentally, a judgment by Judge Rogers in a case called Emeris. They say, like all appellate courts, the Competition Appeal Court does not have unbridled powers to interfere with the decision of the tribunal. Its powers to interfere are set out in Emeris, and this is what Emeris says. Where a determination of the tribunal on a matter identified in Section 12 capital A is brought on appeal, this court, meaning the Competition Appeal Court, will, apart from the well-known restrictions on appellate interference in factual findings, show a measure of deference to the tribunal. Thus, the approach which this court adopts to an appeal against the decision of the tribunal in respect of a merger should take cognizance of the composition and role of the tribunal as a specialist body, which consists not only of lawyers, but also of members possessed of the necessary financial and economic knowledge and thorough grasp of the relevant policy issues required in these kinds of deliberations. Now, let's stop here. Those of you who were present, I think a year or two ago, at one of these conferences at the Competition Tribunal, at the Competition Commission, will recall a discussion that I had with Judge Dennis Davis, in which I tried to suggest that what distinguishes the tribunal and the commission from the CAC is that by law, the tribunal should also comprise of economists, and the same with the Competition Commission. And in that sense, they are expert. They may not be specialists, but they are experts because the product of their deliberation and decision emanates from a combination of expertise in economics and in law. By contrast, there is no similar requirement to the Competition Appeal Court. Now, Judge Davis responded, I think jokingly, and said that, by the way, do you know that I'm an economist, talking about himself, that he's an economist. So this is where the thing gets fascinating, is that what the Constitutional Court says is that the reason you show a measure of deference to the competition tribunal, I suppose in this case, we must also talk about a deference to the commission itself. But one of the reasons you show a measure of deference to the tribunal is because its composition is members possessed of the necessary financial and economic knowledge and a thorough grasp of the relevant policy issues required in these kinds of deliberations. So it's deference to expertise So that's what you do. You defer to expertise. But there is an additional reason why you do not interfere, which is the ordinary rule that an appellate court does not interfere in the factual findings that have been made by a trial court. It does so in instances where it can identify a misdirection on the facts. And it does so in instances where it can come to the conclusion that the trial court was clearly wrong. And the reason it does so, it is for the sole purpose of achieving justice. So just remember this for most of us who will have to be doing this work again. Now the Constitutional Court has reinstated the test that we know is applicable in many other contexts, criminal and otherwise, in which an appellate court does not interfere because it believes the findings to be an error, or it believes the findings to be mistaken, or it believes the findings to be wrong. It needs to be satisfied that they are clearly wrong, or they are a product of a misdirection on the evidence, or clearly wrong. So this is a significant judgment for which, in a sense, emphasizes the power of the tribunal as a final decision maker on facts, so facts that are assessed by the tribunal. But it also emphasizes the significance of this deference to expertise, right? Furthermore, they then say why the CAC was wrong. It says the tribunal embarked on its probabilistic investigation while it was inquiring into the effect of the measure. But the Competition Appeal Court did not factor this, and the tribunal's specialist character and thorough grasp comes back to that first topic, and thorough grasp of economic, financial, and policy issues into its reflections. And interestingly, and somewhat tellingly, even the Competition Appeal Court was constrained to pass the following compliment about the tribunal's reason. The tribunal, to whose careful and comprehensive reasons I pay tribute, made the following key findings. Look, that description by Judge Rogers that the tribunal had been careful and comprehensive equally applies to his own judgment. It was a careful, comprehensive, and I should add, monumental judgment. Then the Constitutional Law comes back to this. It says, based on the expertise of its members, the evidence of economists, and other expert witnesses, the tribunal made certain decisions. Those factual and policy decisions are indeed well-reasoned, insightful, and comprehensive. And then it summarizes those findings, and it ultimately decides that there was no basis on which the CAC could interfere and effectively replace the judgment. But then it made, with the judgment of the tribunal, it made a further comment. And then it says, in its interpretation of section 12 capital A1A, then remember, this is the third element. So in talking about the CAC, the way it interpreted section 12 capital A1A of the Act, the majority, there was a minority, Judge Valley wrote for the minority, and Judge Rogers, together with Judge Victor, wrote for the majority. The majority overlooked sections 7.2 and section 39.2 of the Constitution, thus failing to adopt the corrective interpretative approach to statutes as set out in the court's judgment. Its approach fails to advance the purpose of the Act and to promote the spirit, purport, and object of section 27 of the Constitution. What does this actually mean? Under section 7.2 of the Constitution, there is an obligation on the state to protect, promote, advance the Bill of Rights. Under section 39.2, there is an interpretative obligation that where one is considering the meaning of statute, they need to adopt an approach that promotes the Bill of Rights. And in this case, what they said was that the combined effect of Section 7.2 and 39.2 of the Constitution is that there was an obligation to promote the spirit, purport, and object of Section 27 of the Constitution. And where this ultimately led them to was to say what they overlooked was the impact of the merger on likely price increases without suitable alternatives in relation to consumers of healthcare services at the target hospital. So as I say, assume that to be correct for my current purposes, because the minority said that factual finding was inaccurate. But if you assume that to be correct, the implications are enormous, because what it means is that in its assessment, the Competition Tribunal is now compelled in its merger assessment to look at Section 7.2, Section 39.2, Section 27 of the Constitution. It may not adopt a so-called competitive assessment, right? A competitive assessment that overlooks or pays no heed to what the constitutional requirements are. And this is significant for another reason. I initially opened my talk by saying we have accepted the constitutional regulation of public power, also accepted the constitutional regulation of private power. What we have been thinking about is how the Constitution should regulate market power. Right? Here, what we have is at the center of the assessment of mergers is what impact these decisions of the private parties engaged in a merger, what effect do those decisions have directly on Section 27 of the Constitution? We can think of a range of others, whether it is Section 26, whether it is Section 25, or any other right that in the Bill of Rights. So those rights that are in the Bill of Rights are now to be assessed by the Competition Tribunal. But it also means that those rights are also to be assessed by the Competition Commission in relation to its merger assessment. They may not be relegated into the old public interest on employment, but they need to come to the front and center of the competition analysis. So in support of this point, the judgment then continues to say the Constitution provides for a fundamental human right to have access to healthcare services. In interpreting Section 12(a) of the Act, the Competition Appeal Court majority was required to have regard to the provisions of Section 39(2) of the Constitution, which provides instructive guidance in construing any provision, including Section 12(a), the preamble and the purpose of the Act. This should have been done also with due regard to the state's constitutional obligation to give effect to the rights in the Bill of Rights. Besides, both the Tribunal and the Competition Appeal Court are institutions of the state that bear the obligation to facilitate rather than impede, albeit inadvertently, the right of access to healthcare services. That approach to this interpretative exercise gives context to how the Tribunal and the Competition Appeal Court should have practically embraced their obligation to promote the spirit, purport, and object of the right to have access to healthcare services. In doing so, the pre-existing difficulty to enter the market and the high and ever-rising tariffs consumers of medical services already have to contend with in the private sector would necessarily have had to be factored into that process. Then it says, with that understanding, Mediclinic's predicted post-merger tariff hike in this country of huge inequalities and in this distressed economy would not have been understood and treated as insignificant or minuscule as the appeal court seems to have perceived it. To a wealthy South African, the percentage by which tariffs would go up after a merger is understandably negligible and inconsequential, but not so to an average South African who is not even a member of any medical scheme. Not that members of medical schemes necessarily find these high tariffs any easier to live with. maintaining or increasing the scope for choice of essential and much needed services with particular regard to the plight of the financially under-resourced or the vulnerable should always be at the back of decision makers' minds when dealing with measures. This, after all, is one of the key demands behind the Competition Act. So my sense is that we have entered new territory in which there is now an express obligation imposed by the Constitutional Court that in measure assessment, the competitive analysis or the first part of the analysis must always factor in the Bill of Rights. We also have entered new territory in which factual findings made by the Competition Tribunal should not be interfered with. What we don't know is what the implications of this would be, but it is clear that these obligations which the Constitution fleetingly imposes on the state under Section 7.2 and Section 39.2, because these are usually state obligations. These obligations are now going to be shared obligations. It means that practitioners advising their parties on measures must think, if you're sitting there at Bowman Gilfillan, or rather you're sitting at the bar, let me not mention attorneys, if you're sitting there at Group 621 or at Dumanoka Group and you have to advise a client on a measure, you've got to ask them to pull up the Constitution and to look at rights that may be implicated. Because 3 years down the line, your measure may be overturned at the Constitutional Court on the grounds that you didn't think significantly about the implications of the Bill of Rights. Now, this is major, it is revolutionary, it is a game changer. And secondly, the uncharted territory is around the role that is to be played by the Competition Tribunal. The scope of the Competition Tribunal has been significantly expanded because it now acquires the status of a final arbiter, in effect, a final arbiter on fact. That also imposes a corresponding duty on the tribunal to be very, very careful in its assessment of the evidence that is before it. Because if the judgment is going to be followed, it means that neither the Competition Commission nor parties before the tribunal will be able to appeal successfully, probably 90% of the judgments, which usually involve no more than a disagreement on a factual analysis. All of us will now be required to show that there was a clearly wrong finding, and we will be required to show that there were misdirections. This is not easy to illustrate by any stretch. And then finally, what we also get from this is that the Constitutional Court is beginning to be interested in these arguments. In fact, in the past 3 years, there has been a steady flow of cases coming to the Constitutional Court in which they are beginning to grapple with the implications of the Constitution for the exercise of market power. So what we can say is that market power now finally is subject to constitutional regulation. And finally, we are beginning to see the concrete ways in which this regulation may take place. Thank you. I think I've already exceeded my time in any event. Thank you very much. What I proposed to do was to do questions for around 10 minutes or so. Or,
Thank you so,
or observations, even if it's not questions.
Thank you so much, Advocate, for that. I see we've just received a question now. Let me pull it up for you. So I'm just going to read it to you, Advocate, and then you can just respond. It actually comes from the Deputy Commissioner, Mr. Rachitutu. He says, yesterday, Judge Dennis Davis was scathing on the Constitutional Court majority in Mediclinic, calling this an incoherent judgment. Also a shocking ignorance of mistakes of fact and law, and that this judgment will haunt us. I guess on its ruling on the issues of deference and need to take into account the Bill of Rights. Is it because the Constitutional Court was quite scathing on the CAC? What do you make of this criticism?
Sorry, just repeat, what did he say?
So in essence, Judge Dennis Davis's criticism was that the judgment itself was it was an incoherent judgment, and that it had some shocking ignorance of mistakes of fact and law, and that in essence it will haunt us. It will haunt us, for a long time to come. So that was really the nub of his criticism of it.
Yes.
So the question is,
yes. Because I've presented a much more optimistic analysis of that judgment, which is in contrast with what Judge Davis said yesterday.
Yes.
Yes, I mean, I think that what practitioners should think about is that the judgment is law at the moment, and that we need to engage with its consequences and its findings. And we need to think meaningfully about what the Bill of Rights means for measure assessment. The judgment is not free from criticism. One of my own criticism of the judgment is its inability to engage meaningfully with the thoroughgoing exposition of the facts by Judge Rogers. It's very superficial on engaging with what Judge Rogers found. And that's my only criticism, because when I read this judgment, I went back to the CAC judgment, and I found the CAC judgment monumental, actually quite scary in relation to how thorough it was. And I felt that the Constitutional Court was somewhat superficial in its treatment and that its excessive focus on a previous test, and somehow sort of suggesting that there was a contradiction between the Emery judgment and the Mediclinic judgment by the CAC. I thought that was somehow unfair, because I thought the two judgments, Emery and Mediclinic, could be perfectly reconcilable. But the point I'm trying to draw today is we've got to think about the implications of this judgment, because they are going to be severe, and lawyers need to wake up in their advice to their clients. Their sort of dismissal of the Constitution in competition cases or in major cases, I think that time is over.
I see. Thank you so much. I see the Commissioner Bonagele has his hand up. Commissioner, if you can kindly come on camera and
thanks, Simpiwe, and thanks again to the advocate. I thought, let me pose this question live, so to speak. But before I do that, let me just say that, in fairness, Judge Dennis Davis is coming back to the conference. If he is not joined, I think he's going to join soon, because he's got a panel that comes in immediately after this. And I should also mention that he has complained in the past that we tend to talk about him in this conference in his absence. So we'll give him a right of reply when he comes in. I hope you'll still be there. It is immediately after your talk with Phakamisa. But if you are not there, we will tell Dennis what you said. I thought I should just mention that. The second thing, I find the issues you have raised quite. You have illuminated them for me. There is a third issue which I want to explore with you, namely that the tribunal and now the Concord has somewhat mixed the analysis of SLC with public interest. In the past, this would be treated as somewhat binaries, but it seems here you have a judgment that pulls some weight on both sides of the analysis and brings them together. So they say we find that the measure leads to substantial lessening of competition, and it is not in the public interest to approve it. And so, but I wonder whether this is now an expansive interpretation of public interest, because public interest issues, there's an kind of an exhaustive list, I believe, in section 12. And I am wondering how then this analysis, the implications of putting these together for measure analysis. I think that we've always known that at some point you have to weigh them against each other. So you could find a substantial lessening of competition, for an example, but you could say we will approve the measure because of the, say, substantial public interest grounds or public interest benefits of the measure. So it has always involved some weighing of the two. But I think here there is a lot of conflation of the two. And I'm not criticizing it. I think it's a good thing, but I just think that it's got, we have to think about the analytical implications of this. And of course, you know, for us within the agency, I think the big question it raises is sort of what kind of weight do you put on these as you analyze them. I just thought I should raise that because I think it's also quite an interesting thing to arise out of this judgment. Thank you.
Thank you, Commissioner. Yes, I mean, there is public interest in the broad sense, public interest because something comes from the Constitution, and then there is public interest in the narrow sense, in the sense that it's an item spelled out by the Act in Section 12, capital A. And the judgment itself doesn't draw that distinction. It takes the view that there is public interest in the sense of the impact on the Constitution, because when you look at that particular paragraph that says why there is substantial lessening of competition, that paragraph mentions both in the same sentence and doesn't then revert back to Section 12, capital A. What that might mean for us as practitioners is that we've got to think of a different form of public interest. In other words, a public interest in a normative sense, in a constitutional normative sense. And then we've got to think of public interest in a narrow statutory sense, So because this is likely to arise, there is likely to be a debate as to whether there is another form of public interest which is encapsulated by the Bill of Rights, which plays a role at the first stage of the assessment of whether to approve or refuse the measure. And that's the point I was trying to draw out, is that practitioners have to think about how they advise their clients in relation to what is the impact of a measure on the Bill of Rights. And that sometimes can be coded as public interest. So we shouldn't be too fixated to the narrow definition of public interest, because the Constitutional Court is opening up another possible way of understanding a different form of public interest, which is the public interest as embodied in the Bill of Rights. And by the way, that's not a new thing. I mean, that's, it happens in Delict and elsewhere, that when you're looking at the sort of interests of the community, you look at the Bill of Rights as being the embodiment of what is in the public interest.
Thank you, Advocate. Just a comment. In fact, there are two comments that I just want to bring to your attention. Perhaps if you could just reflect on them briefly. One from Umfundo Ngobese, basically just suggesting how parties have often really used the Constitution and the Constitutional Court, and I guess the court system as a whole, as really an avenue to protect their property rights in particular, but many other rights as well. And so there seems to be, or have been, sort of some level of woeful ignorance in relation to how private parties tend to structure their mergers and their transactions without necessarily considering and contemplating those broader implications that you speak of. And so I think he's then sort of suggesting that, you know, this perhaps should this then in essence be the approach that regulators then also take in terms of, you know, the corollary opposite of that, when they then are assessing some of these transactions and deciding on the direction to take. I think that's a comment perhaps for you to just reflect on and perhaps respond to it. But if I can just put one more to you as well. This one comes from Ubaki Manjenga, the Chief Legal Counsel. And his suggestion is that, you know, your criticism of how the Concord engaged the facts, he says that it appears to him that at the level of facts, the Concord adopted the factual exposition of the tribunal as the correct one, which an appellate court is entitled to do. So perhaps you could just respond to those two.
Yeah, I mean, I agree with Bake. That's what they did. My problem is that they didn't explain why, you know, because they didn't engage in any meaningful way with the thoroughgoing judgment of the Competition Appeal Court. That's the problem I have. What they seem to be suggesting is that merely because there is this apparent contradiction between the Emery judgment and the Mediclinic judgment, both decided by the same judge, that entitles them to prefer the findings of the tribunal over the findings of the Competition Appeal Court. That's fine. I have no problem with that. That a court of appeal like the Constitutional Court is entitled to do. But I think that if you have a judgment as thorough as the judgment of the CAC, I think that if you want to interfere with it, I think there is more that is required. I think you've got to explain where they went wrong. Did they go wrong in their assessment of the expert reports? Did they go wrong in their assessment of the law? Did they go wrong in their assessment of the facts? I mean, where exactly did the CAC get this thing wrong? You know, so I have no problem that the outcome is okay in the sense that, you know, I mean, I also happen to agree that the majority judgment of the Constitutional Court is the correct judgment, because I think that the Competition Act does not allow for this kind of parsimonious approach to the Constitution. It requires the Constitution to be placed at the front and center of the first part of the analysis. And this is the argument I've been trying to pursue, I mean, internally and externally. But I think that it is somewhat unfair, you know, if you're sitting there as a CAC judge and thinking, well, why has this judgment been overturned? And you don't find any directed criticism as to, you know, did I get it wrong in the way I approached the expert evidence? Did I get it wrong in the way I approached the factual evidence? Did I get it wrong in my legal analysis? So why did they prefer the tribunal's decision? And it seems the only reason they did so is because they criticized the CAC for exceeding its mandate as a court of appeal and interfering for no good reason, and interfering for errors as opposed to clear misdirections, which they say it should have done. You know, I mean, I don't know. I hope Judge Davis is here, and at some point we can have a debate. I don't particularly share his concerns about the rupture that this judgment will cause. I think this is a necessary defining moment to major regulation under the Constitution. Sorry, I've now forgotten the first point that was raised here. If you could repeat that again.
Sure. No, it was just a comment by Mfundo around how merging parties have kind of sort of always prioritized their transactions and sort of used the Constitutional Court and the court and the Constitution itself to protect their own property rights. And this seems to have been quite a strong endorsement by the courts of the protection of those sorts of rights. And so I think in many ways he's trying to juxtapose by saying that perhaps then as regulators, should we not take then, especially when it comes to issues such as this, the corollary opposite, to say that, hang on, there are also these other rights as well, which should also be put front and center. You know, access rights to healthcare, for example, amongst others.
Yeah, no, I mean, absolutely. You know, this is the point, isn't it? You know, you can no longer do a major assessment in complete ignorance of what its implications will be on the Bill of Rights. So you've got to take the Bill of Rights here. If you're a lawyer, put the Bill of Rights on the one side and put the Competition Act on the other side, and do a joint analysis of those implications. And this is why the judgment is so crucial, because its invocation of Section 7.2 and Section 39.2 of the Constitution are game changers. You know, that's where I think this is a departure from the parsimonious reading of the Act that takes place in ignorance of the Bill of Rights. I think that's what the instructive part of the judgment is going to be. You know, I mean, I've run cases, fortunately I was not involved in this case, so I can sort of be dispassionate in my analysis about it. But I mean, I've run cases in which you get the sense that there is a reluctance among competition lawyers to embrace the constitutional project in practice. What they do, they embrace it in name. They say, of course, the Constitution applies. You know, of course, don't remind us, but there is no practical evaluation of its meaning, because they mention it at the beginning of their talk, and then in the analysis, they abandon it and they actually do your sort of neoclassical competition analysis. But that's what the judgment punctures.
Thank you so much. I've got a comment in the chat section, and I've got a question from the Q&A section from Heather Irvin, and she's from Bowman's. So I think you'd be very interested in this one. So let me just ask the question first, and then I'll put the comment to you second. The question from Heather is, you know, as practitioners, they've certainly enjoyed the level of engagement that has been had between the tribunal and the CAC in cases such as Walmart, Mattel, you know, when it comes to developing the law on public interest and excessive pricing. And so she's basically asking then, does the Court's decision on deference to the tribunal not put this relationship at risk? You know, the way in which, you know, these courts kind of grapple quite heavily with that. Perhaps, Advocate, before you respond to that, let me put this comment to you so that in the back of your mind, you can have it as well. It really is a comment from Leonard suggesting that, you know, the approach that's taken by the EU courts, as well as, you know, what seemingly seems to be the case now by our court, the Constitutional Court, to really prioritize human rights and to really give deference to human rights, you know, that this seems to be the correct approach when we are tackling competition-related issues. What would be your sort of reflection on that comment as well?
Yeah, no, I mean, I agree fully with that, you know, and you see, one of the problems for constitutionalism, and I didn't define constitutionalism, and it's a system of laws in which power is dispersed, but it's law that regulates society. But another feature of constitutionalism is that it's a rights-based system. The entire legal system is based on human rights. So whether you are talking about how the state should budget, or whether you're talking about how we should contract among each other, or whether you're talking about the conduct of the police, or whether you're talking about what I've referred to as the constitutional regulation of market power. But it's a rights-based system. So it means at the center of every legal analysis is human rights. The problem is that we've tended to subordinate human rights, sometimes in favor of commercial interests. And that's what Justice Mogoeng is trying to move us from, you know. So he's trying to say, put human rights at the center of every legal analysis, and that competition law is not an exception to that rule. Human rights are lagging behind in two fields. So they're lagging behind in private law, and they are also lagging behind in competition law. The reason they're lagging behind in private law is because contractual interpretations are still drawn and analyzed on the basis of the common law. and the influence of the Constitution on contract has not yet been realized. The same applies to the law of delict. Our law of delict is lagging behind because it's still not based on human rights. It's still based on the common law. There has been a growing sense of discomfort that even the competition laws, which is a post-constitutional law, which expressly says in its preamble and its interpretative exhortation that you must factor in the Constitution, there's been a growing feeling of discomfort that the neoclassical economic thinking has, in a sense, overridden the human rights center of that analysis. And this, I think, the Constitutional Court is pushing back against. And I think that is a good thing. But it's an intellectually challenging exercise. And that is why it's much easier to brush it aside. But it is an intellectually challenging exercise that requires us to think beyond the immediate interests of the parties and to think every time that there is always an impact on a right that is in the Bill of Rights. But that requires the Commission to do it as well as the tribunal. So I think that is a good thing. That is a positive thing. The problem is what Heather is saying, which is, what is the implication of the Constitutional Court essentially saying there should be deference to the tribunal on essentially a deliberative process? Because you should look at adjudication as a deliberative process. You know, the tribunal makes a view, the CAC comes with a view, the tribunal improves its next decision, et cetera, and then the principle gets refined over time. But I think that when it comes to the type of deference that the Constitutional Court spoke about, it's deference to expertise, it's deference to findings of fact and expert opinions. It's not deference to the law. There is, in fact, no law that says there should be deference to a lower court if it gets legal analysis wrong. So to that extent, it will not slow down the debate between the tribunal and the CAC on what the correct legal test is. But what it will definitely achieve is it will achieve a sense in which the tribunal, on questions of fact and questions of expert opinion, economic analysis mainly, which is what the so-called expertise really is, on those questions, most of the work will be done finally at the tribunal. So that puts back a lot of energy that lawyers should now spend at making sure that if there is evidence to be led, and it is crucial, that must be done at the tribunal stage because you have no other chance to do it. And the tribunal also has a corresponding duty to be very, very careful because it effectively becomes the final arbiter on economic questions and factual questions.
Thank you so much, Advocate. I see Commissioner Bonegada's hand is up again, but I also see Judge Davies on the platform. Judge Davis, good morning. I thought that we would give an opportunity to you, given your reflections yesterday on the Mediclinic judgment of the Constitutional Court, to just perhaps have a one-liner to Advocate Tembega, just so that we are able to give you an opportunity to reply. He did point out the criticisms, so we would ask that you have an opportunity as well to just put your views to him. And then at the very least, we could give him an opportunity just to engage each other on that. Just the one line.
Okay, well, it's going to be three lines.
Good morning, Dennis.
Good morning. It saved me an email I was just about to send you in this regard. So here's my three-liner, Simpui. Firstly, in relation to the first part of the judgment of the majority, of course, I've argued that myself, and there are many cases which argue that the Constitution is deeply imbricated in the process. And certainly in a pharmaceutical case, which we're about to talk about, Section 27 looms large. That's number one. But number two, as the late Ismail Muhammad, one of my great mentors, would have said, the fact that you've got the Constitution shouldn't be regarded as just some war cry. You have to basically use the facts of a case and inextricably link the one to the other. So whilst I agree that, and we've said this many times, that when it comes to the question of a call on the economics, there should be some deference accorded to the tribunal, as there is on ordinary facts. The problem is that the concept of substantially preventing and lessening of competition is not merely a legal question. And it raises the really profound issue many, many years ago, raised by Professor Etienne Muranic in a famous article about the relationship between mistake of law and mistake of fact. And it's not always easily able to divide the one from the other. So whilst it is true that one should try to use the factual matrix, particularly when it comes to expertise adopted by the tribunal, the fact of the matter is what the Constitutional Court abysmally doesn't understand is what the SLC test is, because it's an inextricable link between fact and law. You can't divide the one out from the other. And if you therefore take the trouble to read Judge Rogers' judgment in Mediclinic, I challenge people to say, well, why in fact is that not a far superior understanding of SLC? I do agree that in fact more work should be done at the tribunal level, but you can't just ask the court to take a legal question without peering into the facts to ask themselves this question: is this a merger which substantially prevents and lessening competition? It's very, very tricky in these kinds of cases to divide out fact from law. One should try as best one can to defer to the tribunal as factual determination. But my guess is going to be, thanks to that judgment, CAC judges are going to say, well, this is egregiously wrong, and then happily go along their own way. So I do think we need far more thought about the relationship of mistake of law and mistake of fact. That's
thank you.
Dennis, should I respond to you? I mean,
I'm happy to. I always respect your.
I don't know if you were here when I began, but maybe not. I didn't realize that yesterday you had expressed yourself in relation to this judgment. So, I went on and gave a very positive exposition of this judgment. But can I say what I think is significant about the judgment? So the one thing that I think is a big take up from the judgment is that the CAC, and I'm not criticizing you in this case, is that the CAC...
I didn't write the judgment, thank God, yes.
No, not this particular judgment. But overall, Dennis, the picture that one gets is that the Bill of Rights plays second fiddle to so-called competition analysis. And what the judgment tries to do is to create a balance between the Bill of Rights and competition analysis, and says actually the two of them should take place jointly at the same time. So I made the point that if I'm sitting at the bar, I initially thought of naming a law firm, but I thought that would not be taken nicely. If I'm sitting in my office and I have a client that comes with a merger, I've got to put the Bill of Rights on the left and put the Competition Act on the right, and think to myself seriously, what implication does this have for the Bill of Rights? And the judgment does this repeatedly, and it uses the lens of Section 7.2, which I've not seen before in competition cases, although I have seen Section 39.2 in some competition cases. And then it says, you've got to always think about what the implications will be for the Bill of Rights. And that's something that I think is a redemptive feature of the judgment. In other words, what it is driving us towards is a rights-centered analysis to competition and competition economics. That's one, and that is a good thing. The problem is the practical one, is how does one actually do this in practice? Because the framing of our competition economists and lawyers is that these are separate inquiries. One does a competition analysis, and then thereafter they look at the public interest. But it introduces a different dimension of what the public interest may mean. There is the narrow public interest in the Act, but there is the sort of broader public interest that is embedded in the Constitution. So that must be thought through quite carefully. Now, on the point where you are criticizing the judgment, my problem with the judgment is that it doesn't take seriously. I mean, I don't mean this in a disrespectful way, but I mean it in a philosophical way. It doesn't take seriously the thoroughgoing exposition of Judge Rogers. Because when I read this judgment, I went back to Judge Rogers' judgment. It is a monumental piece of work.
Correct.
It is extremely difficult to actually pinpoint the errors. And the judgment itself doesn't say what are the mistakes. What it does ultimately is to say in Emery, he set out one test, and then in this case, he set out a different test. but it doesn't do any thorough analysis of what exactly did he get wrong. So if you are sitting there as Judge Rogers, you have no idea why the tribunal's decision has been basically replaced. It's simply used to replace your judgment. So that, I think, is where the problem is. But the overall sense I get about the judgment, that this is a positive step in the right direction.
Yeah, can I just make one point? I agree with you entirely in relation to that. Can I just make one challenge? I have never heard in the 20 odd years that I was in the Competition Appeal Court, with fingers of one hand, have counsel come and use the Constitution in any way in relation thing. So there's a hell of a responsibility on the bar. We're an under-resourced court. We don't have, like the Constitutional Court, thousands of very smart clerks or people like you, clerk there. We have none of that. And we sit there all on our own. And we need counsel to argue exactly the way you're talking. And this is a challenge I hope that you are posing to your colleagues at the bar, that perhaps they should not realize that the Bill of Rights is on floor 1 and the common law is on floor 2. These things should be intermingled. And that's a challenge to the bar as well as to us. I accept the challenge as far as the judiciary is concerned, but there's also a mutual challenge as far as presenting these arguments to judges.
Thank you. Thank you so much, Judge. Thank you so much, Judge. Advocates, I can see there's still a lot to unpack. This conference also has a lot to still unpack, but we sincerely appreciate the level of engagement which you have both brought to this seminal judgment and the seminal piece of work. And we sincerely appreciate the time that you, Advocate Ngwaitobi, have taken to take us through it and its potential implications. And Judge Dennis Davies, we appreciate your thoughts and reflections on it, and we look forward to that article that you promised to pen. And I suspect there will be some sort of reply from Advocate Ngwaitobi also in a scholarly
They may agree with me
to come. Without any further ado, Advocate Ngwaitobi, we're scheduled to now get straight into the book launch of Phakamisa and Nzamela's book. And so if I would kindly hand over to you now to lead us in that. I see Commissioner Bonagele's hand is up. So can I just give him an opportunity to come on camera and to unmute himself? Commissioner?
No, I just wanted to, thanks, Mpiwe, I think you are right. I'm not sure if Judge Davis is aware that we have another 30 minutes or so of launching a book. I know his panel should have started by now. You're fine. Great. Thank you. The other panelists have been informed, apparently. So thanks very much for that.
Thank you. Over to you, Advocate Ngwaitobi and Phakamisa.
Thanks for your generosity, Commissioner. Advocate Ngwaitobi has restricted my rights of talking about my book because of his monopoly of views, but we will continue.
Have I been given the platform by the organizers?
Yes, you have been.
Thank you. All right, I'm very pleased to be in this session again with Mr. Phakamisa Nzamela, who has written probably one of the great books of 2021, second only to Land Matters. And I wanted to give him an opportunity. We only have about 15 minutes to just give us an exposition. I mean, I read the book when it was still at gestation stage. And it's essentially a historical book about where did Black business come from? And for many people who think that the book is about Black economic empowerment, they will, one, be disappointed, but at the same time fascinated, because they will realize that the book takes a period of 400 years of the evolution of Black business and Black merchants and exposes what they did during the period of conquest. And it also deals with who they were. It draws profiles, who these individuals were, and it explores why their efforts ultimately crumbled. So Paramisa is with us today, and I wanted to give him a platform to just give us a short exposition of the book and to have a conversation about what is in the book, why should people be interested, why we should buy it. So instead of doing a Q&A, I think I must give him 10 minutes to just speak without interruption. And then I'll come back after that 10 minutes and ask any questions. Dennis, by the way, you are more than welcome to pose any questions, because I know you to be not just a judge, but a scholar. In fact, you were once described as a Marxist.
Sorry, what do you mean once?
Thanks.
All right, Paramisa, the floor is yours.
Thanks, Tembeka. Thanks, Tembeka. Thanks, Tembeka, for the introduction. The book is called Native Merchants, The Building of the Black Business Class. The book, or in the text, you will find African miners in the pre-colonial era and at the diamond fields. By miners, I don't mean laboring. I mean Africans mining in their own right, on their own account, and selling in their own right and on their own account. It talks to native merchants in agriculture in the 17th and 18th centuries. It talks to native hoteliers in the 1800s. It talks to native restaurant owners, grocerants, retailers. It talks to native newspaper proprietors, printers and publishers in the 1800s. It talks to native transport merchants from the creaking ox wagon to the cranking engine. That is the period of the 1800s to the early 1900s. It talks to natives starting their own financial services institutions. And of course, these things always end in tears, and people fight for their trading rights. For the purposes of today, because we're sitting in a competition commission, I'd like to highlight some of the historical anti-competitive incidents that undermined the growth of Black businesses or this Black business class. In 1867, when everybody flocked to Kimberley, pick on hand, shovel on the other hand, everybody was allowed to mine diamonds on their own account. Everybody, regardless of race and sex. If you are a woman, you could mine. In fact, one of the first 5 diamonds was picked up by a Korana woman. It was a 61 carat diamond, and it was sold for 300 pounds. This is the 1860s, late 1860s to the early 1870s. In 1874, in fact, Black diggers in an area called Balfontein in Kimberley there were 129 Black people that had registered claims out of 135 claim holders in Balfontein. Such was the layout. However, things turned for the worse because of anti-competitive behavior, and Black people lost their mining licenses in Kimberley. I'm going to quote from the text, one chauvinist of the time, Augustus Frederick Lindley. And this is what he says about Black people mining alongside white people on the mines. It would be almost impossible for white men to compete with natives as diggers. The mere difference between their living expenses, the cost of passage from abroad, the rates at which natives would sell their diamonds, and in fact, not to argue further upon a truism, the difference between the general wants, necessities, character, and position of the two races, utterly forbidden. In 1875, there was an insurrection in Kimberley. All the liberals that were for a non-racial framework on the mines were removed from government, and one of them was Richard Southey. And that was the end of diamond mining or mining license holding for Black people. Now, what happens, when Black people are excluded from mining? What do? They do not sit on their back. They look for other opportunities. Obviously, we would know that some of the money that was made in Kimberley made way for investment on the reef, in the Witwatersrand, and people invested in the new gold ventures. But what do Black people do? And I'd like to turn to the story of Amawasha. A group of Zulu men from KwaZulu, the Buthelezis and the Mchunus, saw that in Johannesburg, it was a town full of men. Everybody was covered in soot because of the dust, and there was a need for laundry services. These men moved from KwaZulu, came to Johannesburg, started the Zulu Men's Washermen's Guild. They were called Amawash. Essentially, they enjoyed a monopoly washing clothes in Johannesburg. They made so much money that the Concordia Mining Company in the early 1890s received 350 pounds annually from them. Gets even better. The Braamfontein Estate Company is said to have received 2,400 pounds in rent from Amawash. What happens to Amawash? As the white laundry service providers were emerging, the Amawasha were accused of being unhygienic and causing a health risk with their operations. They operated in the area between Braamfontein and Auckland Park. When the health risks were raised, Amawasha were ultimately pushed out of central Johannesburg into the south, or 2.5 hours by train away from the city center where their operations were. This caused problems because their clients were far. Again, an access to market issue. And unfortunately, the Amawasha could not survive because they were very far from the markets. And new players that were much more mechanized, of course, white, then ran and controlled the laundry services. I want to go to another sector, busing. In the text or in the book, you will find a man called Richard Baloyi. Richard Baloyi was a businessman and treasurer general of the African National Congress. At the age of 25, in 1922, Baloyi was a taxi driver in Johannesburg. At the age of 28, that is in 1925, he had moved up the ladder and he started buying his own taxis. At the age of 30, in 1927, Baloyi was a bus owner. At the time, there were only 5 bus operators in the Johannesburg and Alexandra route. The sector at the time was not regulated and everybody ran their buses as they wished. In 1931, government passes the Transportation Act. Now, this is what Baloyi says, and I quote, "Prior to the coming into force of the Transportation Act, I ran buses between Johannesburg and the borders of Bechuanaland, as well as between Johannesburg and Ramokokstad in the northwest. These services were stopped in order to eliminate my competition with the South African railways. Now, Baloyi was invested in a number of businesses, but his focus was more on the buses. Ultimately, Baloyi and his ilk in Alexandra could not compete. The government then introduced the Public Utility Transport Company, PUTCO, which was white controlled, and it was subsidized. That is how Black people were frustrated by anti-competitive behavior in the busing sector back in the day. And lastly, I want to turn to AWG Champion. Now, AWG Champion is known as the president of the ANC in Natal. I think he was acting president when Dr. A.B. Kuma went overseas to study. AWG Champion ran VUCA stores.
I apologize. The problem is that I wondered whether you because you now have 6 minutes left, but I thought I would give anyone who wants to engage you, etc. With the last, and we've now got a clear message from the organizers that we may not exceed 11. So, okay. To what we want to do? Do you want to just carry on and finish without?
Let me carry on for a minute, and I'll be done.
Okay, that's fine.
This is the last character in the book that I talk about. AWG Champion ran VUCA Africa stores in Durban during the 1930s. He was a general merchant, a fresh produce dealer, and he essentially ran what we call a supermarket, sold hardware and skin hides. He was a licensed and registered retail butcher in Inanda. He had a contract to supply the Inanda Day School with 80 pounds of beef every week. However, Champion was restricted as a butcher. He was only allowed by the authorities to buy 614 pounds of beef per week. Yet, his market demand indicated that he needed to source 1,200 pounds of beef per week. Already in the 1920s, the receiver of revenue in Durban had restrictions on Black people who wanted to sell meat on a non-racial basis. Essentially, if you are a Black butcher, you could not sell meat to a European, and that was to protect the European market. Black people like Champion tried to sell to everyone, regardless of race. However, they were threatened with loss of permits. I'll end it there. Thanks, Commissioner, and thanks, Tembeka.
No, you can't thank the Commissioner. This was my slot, so I gave you an opportunity in my slot. The Commissioner has nothing to do with it.
I grant you 10 more minutes for questions, Pakamisa. That's on me.
That's really a wonderful. So if I'll then facilitate perhaps a Q&A if there are people who want to ask questions.
Perhaps if I can just remind the audience to place their questions in the Q&A function so that we can be able to have sight of them.
Yes, I mean, maybe I could start by asking just a general question on the issue of how the European merchant class, specifically the Dutch merchant class, how that began. There is a story from the Van Riebeeck journals that one of the problems that the Van Riebeeck and his people encountered when they arrived in the Cape was they wanted labor, and they wanted meat, and of course they wanted land. And the way that was then achieved was essentially by just pushing out Khoi people from the pieces of land they occupied. But most importantly, it was through these cattle transactions. But the company had to agree, guaranteed access to the markets. It agreed that it would buy all of the meat that they were selling. And it also agreed that it would provide them with labor, but that labor was the labor of enslaved people and local Khoi people. So I wonder if in your book you made reflections on, if you look at the beginning of the sort of Cape economy as such, it began as an exploitative economy, and whether that had any impact on the development of a self-standing, free native class.
Sure. So when the Dutch East India Company successfully, and it is what you are asking is in the text of the book, when the Dutch East India Company successfully built a trading post in the Cape, they initially traded cattle and salt with the Khoi. Now, when they were stationed, they realized that there was going to be demand from crossing sheep that were passing by. These were the English or the Portuguese. And they started building a market. Of course, the Dutch East India Company had come here with its own employees and didn't want to have idle men. So what they do is they sent an instruction to their employees and said, go and take over land, that is called Khoi land. You will start operations, we will give you cattle, we will give you access to the market. That is how Dutch empowerment actually started. You could not have the story of a Dutch businessman does not arise in the Cape without the support of the Dutch East India Company. How did that affect the Khoi? Of course, it affected their trade because the Dutch East India Company ran itself like a monopoly. So the Khoi wouldn't have had access to such markets. However, because history is not written on a straight line, there were Khoi people and beggars that did interact, the free beggars being the Dutch, that did interact on trade. But certainly it would not have been with the Dutch East India Company. Of course, there were Black people who were formerly enslaved, Tembeka, who bought their freedom and became business people. I talk about Black Maria, a woman who owned wine farms and cattle, and they did trade with the Dutch East India Company. But of course, sadly, all the formerly enslaved who started businesses, their businesses never carried on to the next generation, especially if they were men. Tembeka has disappeared.
No, I'm still here. I think the organizers can tell us about the questions because I just don't know where the function is for this thing.
Oh, all right, no problem, Advocate. There is a question in the Q&A function and there's also a comment as well. So perhaps let me start with the comment, Pagamisa. It's from the Commissioner Bonagele. His comment is, what is the one thing that needs to be done now to revive Black merchants? He's asking perhaps as a BE, what might be your thoughts on that? And perhaps let me just put then this question to you as well, so that you can just address them all at the same time. Does the book talk to the obligations placed on Black business entrepreneurs to change the status quo in the ownership patterns in the country's economy? And this question comes from Sia Makunga. So just those two.
I'll start with the commissioner's questions. I made 3 examples. One of the Amawasha, one of the transport provider, Richard Baloyi, and one of Champion. All those 3 characters were frustrated by anti-competitive behavior. I'm not a competition lawyer, but I've always asked myself, do you fight anti-competitive behavior through traffic regulations, or do you use competition law? I think the Competition Commission has a role in the advancement of Black business people and enabling an environment where they can compete, because historically they've been unable to compete because of anti-competitive behavior. I think that's one aspect of it. The other part is that, you know, Black people have got to take succession planning quite seriously. If you look at some of the BE companies today, the book is not about BE, but if you look at a lot of BE companies that were started in the mid-90s, when you go to their websites, you struggle to see a layer of management that goes beyond the founders. I think there's something that's got to be fixed there. Otherwise, those companies will not reach 50 years. The book does not talk about triple BE ownership patterns, Mr. Makunga, but what those guys did back in the day, they owned their businesses, and how? To raise capital, they clubbed together in stokvels and they invested. I write about how Tsala ya Batswana, Sol Blackies, was built. It was a group of guys in the Free State pulling money together and investing in these things. I think there are lessons to be learned from those stories. Thank you. I must say, if you buy the book and you do not find it interesting, I will give you back your 320 Rand and a bottle of wine for wasting your time.
I don't know if that is a reflection of a confident author, because I can tell you from my own books, if you bought my book, you would never get your money back. All right. Anyway, we've now really run out of time, and I want to thank the commissioner for the extended 10 minutes. We've now exhausted even that 10 minutes, and we can never finish discussions on native merchants. So yeah, there are, I think I saw like 160 people here. So imagine if all of the 160 people bought your book, you would have more than enough money to buy bottles of wine. So thank you for being here, and thank you to the organizers. I will now switch myself off and go back to being a spectator that I should be.
Thank you very much for your generosity, Tembeka, and to the Competition Commission. Thank you very much. I appreciate it.
Thank you, Mr. Nzamela. You know, as I was listening, I found, first of all, it's so important to re-centralize the notion that Black people have not always been a source of labor. They have been industrialists, they have been business owners, and that there was a very deliberate plan, which I think speaks to what we were talking about earlier, and how regulation of market power has to be a constitutional issue, because it speaks to the transformative justice aims that the Constitution has as its heart. And, you know, part of what the freedom, you know, I could go into a whole diatribe, but what I loved about what you've re-centralized for us is that just as our Competition Act recognizes Black people not only in their role as employees, but as small business holders as well. And I think it's that industrial spirit that we want to evoke again. And in particular, I love how you mentioned in your address that indeed there were also Black women who were playing those roles. And I look forward to the Native Merchants Part 2 which will have a review of all of the women during those times who were making such similar remarkable steps forward. Now, if we can just shift frame a bit now, we've spoken this morning about constitutionalism and the Mediclinic judgment and the right to health, and we're going to return to those themes now. This plenary session, plenary 4, is titled The Pharmaceutical Industry, Access to Vaccines, Diagnostic Kits, and Related Products during and after the COVID-19 pandemic. And as you all have seen, I think what the pandemic put into sharp focus is one of those areas of competition and IP nexus, things like patent protection, and where in fact are these benefits and additional rents being assumed? Who is society the beneficiary of some of the patent protections that we've seen in the recent past? And in addition, this session seeks to learn from the development and the contribution and from the distribution of COVID-19 vaccines in thinking about issues of patent protection, and in particular competition's role when looking at that going forward. So I'm going to invite our moderator, Judge Davis, who we've already spoken to this morning. If you can turn on your camera again, and I understand our panelists are all here, and if they can indicate their presence by turning their cameras on. And I look forward to this discussion, which I'm sure is going to be deeply interactive, as was the first. I hand over to you, Judge.
Thank you very much, Mpumi, and I cannot but endorse what you just said. I mean, it's rather ironic that earlier this morning I was correcting an article that I'd submitted on transformative constitutionalism, and one of the reviewers said, "What are you talking about? Why does the common law need to be changed?" And I thought, do we really still live in a society that doesn't understand the accountability of private power? But I'm afraid in the legal system, the answer is sadly generally not. So your point is well made. Anyway, here we are, slightly late, but nonetheless, to deal with a really important question of COVID and the pharmaceutical industry. I know that some of the speakers are going to range beyond the question of COVID itself, because there are really interesting questions to be raised in regard to the question of the pharmaceutical industry. There are specific questions about excessive pricing and whose responsibility that is. There are broader questions about the role of competition law in relation to the access of medicines and health services generally. And then, of course, there is something which I think we also need to touch upon, is the relationship between intellectual property rights and competition law, all of which essentially are up for discussion, as indeed is the important point in the exchange I had with Advocate Nicola Toibi with regard to the role of the Constitution in general and Section 27 thereof in particular. Now, I'm not quite sure what batting order to Doctor, because I haven't been told, but I have been given a list of our panelists, and I'm going to just read briefly their CVs. And since they were given to me in order, I will use that order for their presentations. We're obviously running late, but we've still got probably an hour and 3/4. So I hope that everybody will do a shortish presentation, 10 or 15 minutes the length, rather than, with respect, drone on, although they're terribly interesting panelists, so we can actually have an exchange between all of them. So in the order, and I'm sorry, Fatima, that you are the opening bats person, because your name came up first, but actually I think that's not a bad idea, because Fatima Hassan is a human rights lawyer. She's a social justice activist. She was the founder of the director of the Health Justice Initiative, former executive director of the Open Society Foundation for South Africa. She had a very long history of social activism of the most wonderful and commendable kind, including important work done during the HIV/AIDS problem, which of course we don't need to go into. That is course, the way in which we always seem to have to be challenged by a government that takes eccentric policies on crucial questions. Let me introduce the rest, and then we will follow that order. Dr. Clive Ondari, over 30 years of experience in pharmaceutical policies and programs, having worked for the government of Kenya and the WHO on various assignments. He has a doctorate in pharmaceutical science and Master of Science in Business Administration. He has served as the WHO Coordinator for Medicines Access and Rational Use, as well as the Coordinator for Safety and Vigilance. Currently the Director for Health Products Policy and Standards in the Division of Access to Medicine and Health Products at the WHO headquarters. And welcome to you, Dr. Ondari. The reason I didn't say that to Fatima is because I know her extremely well. And James Hodge, I also know extremely well, and who has the oddity, even in my career, of being on both sides of the fence, first telling me how wrong the Commission was, and now telling me how right the Commission is. So please understand, James, I'm a bit schizoid in regard to this question, but there's no question that, that the Commission is extremely fortunate to have him as the Chief Economist of the Competition Commission, Acting Deputy Commissioner. I've always regarded him, if not the leading, certainly one of the leading experts in competition law, economic experts. He's incredibly courageous and I thought unbelievably innovative and thoughtful contribution during the Walmart inquiry, for which I had a huge amount of admiration. And he holds an MCOM from UCT, my alma mater, and a huge amount of distinction in the field. Greg Harman, again, somebody who's no a stranger. Greg is the Managing Director at DRG. He's had more than 30 years of experience in practice in the field as an expert witness. He's been an expert witness in South African cases, an unbelievably formidable expert with very, very thoughtful reports, which certainly have been incredibly helpful to us, as they have been to courts and regulatory authorities in various parts of the world. He holds a master's degree in competition regulatory economics from the City University of London, and like James, is extremely distinguished in his field. So Fatima, over to you.
Thank you, Dennis, and to the fellow panelists. So I think we were asked to just give a few introductory remarks in the first few minutes. And, you know, the first thing I want to say is that this pandemic was supposed to give us an opportunity to reset our competition law, intellectual property law, and the way in which we approach the really, what I think is a pernicious power and role of the pharmaceutical industry, not just in South Africa, but in Africa. And I think we failed. And, you know, it was an interesting conversation this morning about the Mediclinic judgment. And one of the phrases there that 10 judges have used is who protects the public? And I think I want to keep on returning to that, because for us, this is not an academic discussion about the impact of the Mediclinic judgment or the impact of our amicus submission in Babalegi or the work we did in the Hazel Tau case, but it really has a life and death significance in terms of how we actually deal with the intersection between competition law, the constitution, and obviously our very outdated and very TRIPS plus intellectual property regime, where even in the middle of a pandemic, our government has not seen fit to actually table the patent amendment bill, which could have had a significant impact on access, not just to diagnostics, but also to vaccines for people living in South Africa and elsewhere. So the first thing I wanted to say is that we can't have any economic recovery in South Africa and on the continent without widespread access to vaccines. And our vaccination rates in Africa, because of a number of factors, including a drip feed of supplies from certain monopolies, and in our case, duopolies, means that Africa has less than 5% of people fully vaccinated on the continent, whereas countries in the richer north and global north are looking at 50%, 60%, 80% coverage. And you know, we've dealt with the myths about that this all has to do with Africans not being able to take vaccines or not knowing how to tell time or being anti-science or being vaccine hesitant. That's certainly not the systemic reasons for why the continent has such a low vaccination rate. I mean, the second point I want to make is that vaccines are not cars. They're not perfumes, they're not jewelry, they're not wine. They're life-saving interventions, similarly diagnostics, and it's what we argued with PPE in the case of Dis-Chem and Babalegi as well. And so the way in which we approach the constitutional imperative to make sure that there's broader access and immediate access and affordable access to these life-saving interventions really needs a reset. And I think the challenge has been put on the table to make sure that we actually hold private power to account and bring in more of these arguments in relation to the impact it has on Section 27 of the Constitution. What we argued in the Babalegi case, for those of you who don't know, we intervened as amicus and we were admitted. We made these very arguments that the Constitution, or the arguments that have been dealt with in the Mediclinic judgment, that the Constitution has everything to do with interpreting the new Section 8 of the Competition Act related to excessive pricing. And maybe, Dennis, we can come back to that later. I was very fortunate to be the lawyer in the Hazel Dow case. And you'll remember that we're dealing with an industry that doesn't disclose the basis for its pricing. And that is a general issue that we have in the industry in relation to how pricing is determined, particularly in this pandemic. We've had to do a lot of work to try and get the secrecy to be lifted. We haven't succeeded. There's very little transparency. And I use the word pernicious because a lot of these vaccines, and I'll come now to the issue of the vaccine situation in South Africa, were actually publicly funded by a lot of governments in Europe and in the US. So the issue of pricing, I think, is going to be a key test for how, not just in terms of access, but also in terms of affordability for countries going forward. And I say this because when I said you can't have economic recovery without widespread access to vaccine, if we are talking about annual vaccination programs or biannual vaccination programs, you're looking at a situation of having to administer potentially 2 doses of vaccines to everybody, even now teenagers, but particularly people who are adults, healthcare workers, people who are elder in the whole continent, maybe even twice a year or 8 months apart. And the current epidemiological and public health sort of scenario is that this is going to happen for the next few years. So clearly the vaccination access issue is an immediate priority because it's not something that's going to be once off. So if we come to the issue of vaccines, I think that, James and I have had this conversation many times with the Competition Commission team. There's been a lot of fantastic work that the Commission has done on PPE and around price gouging. And like I said, we also intervened as amicus in the Competition Appeal Court, both in the Dis-Chem and Babalegi case. You'll all know that Dis-Chem withdrew its appeal. We like to think that after our admission as amicus, they actually withdrew. But I think that it's important for civil society to make use of the amicus intervention. We can talk about that later. But the focus has been on price gouging in relation to PPE, in relation to face masks, which is important because non-pharmaceutical interventions are equally important to vaccines. But where we as a government haven't, or as a country haven't actually dealt with the duopoly that currently exists in relation to South Africa for Pfizer and Johnson & Johnson, and then the monopoly that exists in the continent in relation to a handful of vaccine companies that have done significant work, important work, research that relies obviously on public scientists and previous knowledge, but where those vaccines are not made widely available and where the licensing arrangements that are currently in place are clearly not sufficient. So what we have is a situation where the vaccine manufacturers have basically been left to their own devices. They've been able to negotiate the contracts that they want. They've been able to extract export concessions. They've been able to set the price that they want. They've been able to ensure that there are broad indemnification and liability schemes, which you and I are funding as the public in South Africa and also elsewhere in Latin America and Africa. So there's been an absolute amount of power that has been exercised by the vaccine companies, and many organizations around the world are trying to lift the lid on that. There's just been a report about Pfizer's contracts around the world that's been issued by Public Citizen. You all know the work that we tried to do with the New York Times to expose what's actually happening with Johnson & Johnson, not just in terms of its lack of timely delivery of supplies to South Africa as we were entering wave 3, but also in terms of the millions of vaccines that were actually exported to Europe, where government had to agree to that. Now, government may say that we had to agree to these contracts because we needed to get vaccines to people, and so no matter what. But I think that there is still a role for the regulator and for regulatory agencies, particularly where you're given the power in terms of the Competition Act to be able to do something. So when I talk Dennis, and you must just remind me about time, about the duopoly that exists in South Africa. I think that one of the parts where it becomes tricky about arguing why we only have two companies providing us with vaccines, I think, is obviously in the case of medicine pricing and the way in which our medicine approval or vaccine approval regime, and I'm just using medicines in a very broad sense, is that obviously we rely on SAHPRA. So unless something is approved for use in South Africa, it's not like just any car or any piece of jewelry or any bottle of wine. There are particular regulatory obstacles and barriers to how a vaccine gets actually approved in South Africa, which is the reason why we're only using Pfizer and Johnson & Johnson. So that means that the regulatory system has actually in turn created, not in an intended way, but a duopoly where you can only rely on Johnson & Johnson and Pfizer. Now, with Pfizer, you can look at our vaccine supply sheets that we've been tracking for the year. You'll notice that about just maybe over half of what the contract was has actually been delivered, and there has been a consistent, I would call it consistent, but consistent drip feed of supplies, which is why South Africa had to have an age-based cohort prioritization for the program. Johnson & Johnson, on the other hand, even with the license to Aspen, so that's encouraging economic participation, it's encouraging South African businesses. Aspen gets the license for fill and finish, but still with that license, they've been unable to even meet more than 8 million of the 31 million contract for Johnson & Johnson. So there's an issue there, and I believe that the Competition Commission actually could intervene, particularly because the license was actually given to Johnson & Johnson, which is meant to provide 400 million vaccines to the rest of Africa. So Africa is literally waiting for vaccines, waiting for supplies from COVAX, from Johnson & Johnson, and potentially maybe one or two other companies, while manufacturing is being scaled up and while the knowledge is being hoarded, because vaccines, even at the beginning of the pandemic, even though we were promised solidarity, vaccines with all of the public funding and investment are now being treated as a commodity. And it's a continuation of the way we've always treated, or we as in the way in which the industry and government has always treated life-saving interventions. And we saw this with the HIV/AIDS crisis as well. My last 2 points is that the other opportunity, I think, for our competition jurisprudence, and obviously we as activists and as activist lawyers working in the space, obviously, we're really happy with the Mediclinic judgment, right? But the one issue where, again, where government has not taken the necessary steps, it hasn't passed the necessary regulations, means that the Competition Commission is the only authority then able to help us to be able to examine the pricing. And that's on Section 21 medicine approvals. So if a vaccine gets a Section 21 approval, there's no medicine pricing system, there's no single exit price system, there's no global benchmarking. And separate from that, we need to deal with the Department of Health and its global benchmarking regulations. But Section 21 approvals are basically immune from price scrutiny through the normal Department of Health system. And so I think what I'm trying to just stress is the intersection between how the health department operates this entire global medicine pricing regime for South Africa. And what COVID has done is actually expose in relation to Section 21 approvals for vaccines, or maybe temporary treatments. We don't know what's going to happen with the Merck treatment that may potentially be licensed or not licensed. But if you look at the prohibitive cost of that, and if that is an option for reducing infections and death by at least 50%, that is a drug that we would want to be able to use. So there's various issues around the Section 21 regime. There's issues around the disclosure of the cost basis and the cost assumptions for a number of the diagnostics and vaccines. And when I said that PPE became the focus and vaccines didn't, equally so diagnostics. We're a continent where we need to test more. We don't have a true sense or a handle of the pandemic. It's an immediate public health imperative that we are able to test more people. And so you can't have monopolies like Roche or pharmaceutical companies not sharing the vaccine knowledge. The only thing our government has done to try and remedy that in the past year, and as you know, it's been blocked by very powerful pharmaceutical companies and CEOs and richer nations, and that has been the TRIPS waiver. But in the absence of the TRIPS waiver, in the absence of passing the Patent Amendment Bill, in the absence of the regulations of Section 21 pricing, what else do we as the public, who protects the public, what else do we have to be able to rely on to try and change the status quo and try and seek some remedies? So if there's two things, James, that you want to focus on for the next few months, I think It's time our government got a state license of J&J, because clearly J&J cannot meet demand, not just for South Africa, but the whole of Africa. We need multiple full manufacturing license there. And then obviously we need some preemptive work on the situation with Merck and the potential of the new treatment being introduced in our country. Thank you.
Thank you very much, Fatima. I want to come back to some of these questions, and certainly let me say right up front, your very, very interesting observations with regard to the price, cost, returns, etc., the Pharmaceutical Association, is something I deeply, deeply, deeply regret, if I can emphasize, that the HIV case all those years ago, the antiretroviral one, was settled and never got to us at the Composition Appeal Court. I was waiting to apply Section 27 to that, and my guess, and I put this out provocatively, my guess is that the pharmaceutical companies did not want to come to us because they would have had to disclose their returns. They would also have to disclose, as Marianne Mazzacuto has often said, that the state subsidizes his research as opposed to the private companies, and that the returns are therefore outrageous. But perhaps we can come back to that later. Thank you very much. Dr. Andari, the floor is yours.
Thank you, Judge Davis, and thank you again, the organizer of this forum, for sending the invitation to us. As I was listening to Fatima speaking, I'd actually changed plans from sharing a PowerPoint slide to making remarks, because Fatima had actually indicated some of the most crucial items for this dialogue. As I'm not a lawyer, I will speak to the areas of work of the WHO that try to even the ground for manufacturers, distribution, and rational use of medicines and health products, vaccines included. But just to highlight that during this pandemic, we've seen that of the more than 6 billion doses of COVID-19 vaccines distributed globally, to perhaps just about 50 countries are remaining with a coverage of 10%. And those are the countries that Fatima highlighted. We've seen the underlying access problems being manifested fully during this pandemic. Those are in many folds. Fatima did highlight some of this in terms of the R&D funding, but also the way manufacturing of medicines, vaccines, and other health products are situated around the world. During this pandemic, again, ably highlighted by Fatima, we've seen excessive pricing of products going from protective equipment, face masks, hand sanitizers, serological tests, and of course, many other items required now for the administration of vaccines, including syringes and needles. Active and enforcement of anti-price gouging laws has been difficult to implement. And we look towards the Commission in South Africa and the processes that you are discussing at the moment to see how that works. In the past, again, as Judge, you have indicated, there have been interesting cases coming through your judicial system, and I've informed the world on how to deal with some of these complex matters. But we see that the underlying issues on access, affordability of medical products that we're seeing now are going to be with us as they've been going forward. We are unfortunately going to be seeing unaffordable high prices for medicines and products going forward for both households where they're out-of-pocket expenses, but also for health care systems. So this is important that we actually see how to implement short-term measures while at the same time looking at long-range interventions. Implementing price regulations and policies has been very complex over the years. Obviously, the transnational nature of most of the manufacturing around this sector, and make it very difficult to trace products and hence trace the pricing components. But we as the WHO have put out a price policy guidelines that many countries are relying on for domestic price policy and strategies intervention. I think one of the things that we are obviously grappling with, and many member states have been taking up, and quite recently at the World Health Assembly, a resolution was passed that addresses the issue of localization of pharmaceutical manufacturing, where we have seen countries that are heavily dependent on importation as being at great risk to shortages and in supply insecurities. Just to highlight that we see that in low middle income countries, where pharmaceutical imports globally are less than 5%, these markets are deemed as very low priority to most of the pharmaceutical industry. Whereas obviously the burden of disease in many respects exceeds more than half of the global burden of disease. So diversification of production capacity has now become very, very crucial. But of course, in a pandemic like this, to upscale production to meet the global demand is definitely a tall challenge, but this is something that has to be seen in the medium to longer term. The resolution that I'm referring to in so far as supporting strengthening local production is the World Health Resolution 74.6 that starts to look at what are the key levers that member states can pull in order to strengthen local production of medicines and related products. Just to highlight around that resolution, the articulation of the Director General WHO, noting that boosting manufacturing won't happen by itself. It will require some of the elements that this panel is been asked to deal with, and that is looking at how to stimulate transfer technology, in addition to obviously equitable distribution of available doses in the case of vaccines, but looking also at elements such as voluntary licensing. And of course, this has been what has triggered the government of Costa Rica to work with other governments and the WHO Secretariat in setting up the COVID-19 Technology Access Pool, CTAP, to facilitate some of the exchanges that would obviously be important to be able to transfer the necessary technology. Other measures, obviously, as been highlighted by Fatma, include the issues related to waiving of intellectual property rights that the government of South Africa and the government of India are championing. I'm delighted to join this panel, of course, where you'll be talking about, and you have been talking across the sessions on anti-competitive environments and how to manage market dominance by companies. Obviously, we as the WHO have worked over the last 30 years to ensure that the critical elements for generic competition are in place, the standards and the regulatory mechanisms and measures that Fatma talked about are in place. We've had quite recently to implement global tracking of shortages of products so that countries have better visibility on how products distribution is going. But it is important that the activities of competition authorities, such as the Commission, obviously strengthened, and the experiences of such commissions shared across the world. It is through this sharing of experiences and cooperation of anti-competitive measures authorities can help to bring out the best practices. Of course, enforcement measures and actions are much more complex, but we look towards countries' progressive systems like yours to be able to share those experiences worldwide. Another element that obviously is challenging in the area of health products is, as again Fatima indicated, transparency of contractual arrangements between private entities and public health systems. At the very least, I challenge anybody to find any agreements in great details that have been entered through governments and vaccine producers during this pandemic, or in any case, before the pandemic. Whilst the governments are endeavoring to create transparency of the investments they make into pharmaceutical R&D, it is obviously difficult at this point to say how much discounting is going into the offers that various health systems are getting, and how that information can be shared across the globe so that other health authorities are able to benefit. Nevertheless, we've started a platform to collect transparently global pricing that is available, and we will make this data increasingly available to countries and programs to be able to use in implementing more rational procurement processes. Judge, let me stop here. My time, I'm saying I've exhausted my 10 minutes, but I'm really delighted to join this very, very powerful panel looking at competition measures and what governments can do. And we are looking forward to you to tell us what, as WHO, we can do to better even the level ground for pharmaceutical manufacturing and distribution. Thank you, Judge Davis.
And thank you very much, Dr. Ndari, for your very thoughtful comments, which, of course, I think wonderfully locates the debate in both national and more global considerations. Our next speaker is James Hodge. James, the floor is yours.
Thanks, Dennis, and thanks for this platform, and welcome to the audience. I think, as has been said out already, the Competition Commission has been active since the beginning of this pandemic in a range of areas. So the most obvious one is in PPE, where we had the price gouging cases, both for private retailers, but also price gouging in public procurement, where it sort of supplements the, let's say, the investigation into corruption as well. We also acted early around exemptions, which helped negotiate down the price of PCR tests. But we are, at the moment, quite concerned that the price of those PCR tests haven't come down. And with assistance from the WHO, we've seen that the test kits have come down in price substantially over this period. And we would expect that similarly, the pricing in terms of the actual administration of the test, or the costs of administrating the test, would have come down too. So that is something that's on our radar as well. Fatima has also highlighted the issue of vaccine, and maybe rightly or wrongly, we've sat back somewhat just to see where government has gone with this. And because it has been a government negotiation and government rollout program, there may be less role for the Competition Commission currently. But I think, as she rightly points out, there may be issues of supply going forward, and we are in this for the long run. So it's something we can't ignore for now. And companies that may voluntary license now or waive patents now may invoke those patents at a later point. So I do want to talk about how we're seeing the relationship between IP law, constitutional law, and the Competition Act as well. The last thing before I do that is to mention that as Dr. Odari indicated, the capacity around manufacturing when you do get voluntary licensing or compulsory licensing has become a critical issue. So the African Competition Forum has just launched a research program around the generics industry and manufacturing capability on the continent, and how that can be developed and furthered in terms of having the manufacturing skills on the continent, the trade agreements in place such that we can actually take advantage of those voluntary licensing. So as soon as something comes off patent or is licensed voluntarily, it's the capacity of your actual manufacturing industry and generics industry that then comes to the fore as determining whether you're going to get competitive prices or supply for that matter. But maybe turning to just the issue of IP law, constitution, and competition law. I think we all accept that innovation is part of the solution. Healthcare benefits from innovations, but at the same time, excessively priced pharmaceutical products denies us the benefits of those innovations and undermines the constitutional right to healthcare. So the question, as was almost posed in the beginning for this panel, is where does that balance lie? I think one view that I personally hold is that IP law is often believed to grant monopolization rights, and is often believed that a monopoly price, in fact, is necessary to incentivize innovation. And I think those notions do need to be challenged, because IP law, in essence, just grants the right not to use that particular invention or product. But in a broader market, and what we see generally is that there are many competing innovations, many competing innovative products across society. And so normally in an area where there is innovation, there is still competition that can constrain the returns. And so one doesn't need a monopoly price in order to realize that. In our observation, the biggest problem is in fact in healthcare. And I think this is recognized in the TRIPS agreement, which has a particular carve out for public health. But in healthcare in particular, you're dealing with essential life-saving products. And that means, to use economics terminology, inelastic demand and the ability to price at almost exorbitant levels and still have people willing to pay that price in order to get that life-saving service. What we also see is that there is often not the same degree of competition. We've seen pharmaceutical companies over time gradually specialized around different areas of research. And whilst with vaccines, we've got a number of vaccine producers, we see differences in their efficacy. We also see, as we saw with HIV drugs, that often the combination of vaccines can provide even improved protection. So despite the fact that we even have some competing vaccines, there's probably the scarcity of supply, et cetera, that can allow excessive pricing for these as well. And I think, as rightly noted by Fatima, almost the essential life-saving drugs, whether they're cancer drugs or vaccines, typically have their base in state-funded tertiary institution research, primary research, which is the most blue sky and the most risky. And therefore, if we assess the contribution of almost taking some of these just through the final trial phases, the returns that are provided to some of the companies is excessive relative to their contribution and risk. I mentioned that TRIPS recognizes, and our own patent law recognizes, that there is a public health imperative, that any implementation needs to be consistent with that, and that provides a scope for compulsory licensing, not just on emergency basis, but also on the basis of public non-commercial benefit and use. And I think what's interesting to draw out is that very often TRIPS uses as a benchmark the fact that if you have gone to the patent holder initially and sought to get a license on reasonable commercial terms as a precursor to invoking compulsory licensing, the reasonable commercial term starts to, in my view, set a benchmark that we can often use in competition law in assessing excessive pricing. Our own Patents Act looks at things like where the patent is not worked, we can invoke compulsory licensing, where the demand for the patented article is not being met to an adequate extent and on reasonable terms, and the refusal to grant a license on reasonable terms. So this concept of reasonableness comes through consistently in the TRIPS and IP law. And that's a concept that we also have incorporated into our excessive pricing law, because it's not just whether the price is above the competitive price, but also whether it is unreasonably so. So finally, just going to the competition law, as I indicated, our current law now is based on a competitive price and the reasonable relation to that. Previously, it was based on economic value. And I think, in fact, both concepts have some relevance here. So in looking at a competitive price and the reasonableness, where I think the Constitution comes in quite firmly and to provide a practical application of the recent Mediclinic judgment. So how do we bring in Constitution in terms of not just the public interest in a merger, but the actual assessment of substantial lessening of competition, or in this case, excessive pricing? But the Constitution can be invoked on the reasonableness side. So we could look at a competitive price, which might bear some relation to manufacturing costs or even a return on R&D, but it's the reasonableness of the pricing above that should come under scrutiny. And in the context of access to healthcare, we shouldn't be granting wide latitude for a big difference between the actual price and the competitive price. Already we have within our Act the factor in considering that reasonableness, the extent to which the state has funded this. And as has already been highlighted, the state funding is a significant feature of often life-saving drugs and has been a significant feature of the vaccine program, even if so far as just the advanced payments have propelled the trial process and enabled those companies to fund the development of the vaccines. So we do have already within our law measures that we can use to look at the reasonableness. On the competitive price, there are probably two areas that we think we should look at. I've mentioned that in IP law, there's this concept of a reasonable return on licensing. And licensing means that the manufacturing costs are taken into account and it's a royalty fee on top of that. And there are benchmarks for reasonable royalty fees. And so that does provide one of the bases, and where there is voluntary licensing in place, one can look at what are those royalty fees and assess the reasonableness of them. The other is a value-based and affordability-based approach. So the World Health Organization does look at, in a sense, the pricing of drugs based on the value they provide. And that's based on your quality-adjusted life years and weighted by your country's average GDP per capita. So it's almost, in essence, saying, well, if this drug extends a life by another year, that life, correctly or not, may be valued in terms of the GDP per capita. And the cost effectiveness needs to be assessed against that standard. And that standard then naturally means that lower income countries should get lower prices. And I think that's already an accepted principle, but the extent to which it is substantially lower in lower income countries is probably the biggest problem that we face, not the principle that there should be some differentiation. So we can use those tools to, in a sense, assess the value and the affordability as well. And affordability, again, invokes those constitutional rights, because generally the public health system is not made available for certain life-saving drugs where it becomes unaffordable. And so they deny access through the public health system where the price is priced at a level that's excessive. So we can use that affordability, and it relates again to the concept in IP law of not working a patent in a country. If it's priced excessively, it's not going to be worked. It's not going to be adopted by the public health system and made available to people. I think just touching on two last things before I hand back to you, Judge, is, I mean, it has been highlighted, the lack of transparency, and what we've seen at the Commission is also enormous frustration around jurisdiction, just getting costs, getting R&D. There's no incentive to make that transparent, and jurisdiction is a major issue for a developing country. These companies are head officed in Europe or the US, and jurisdiction is consistently invoked. But where the amendment to the Act now around a prima facie case is incredibly useful is that we can estimate the manufacturing cost based on the active pharmaceutical ingredients and the like. We can work out affordability without the information from the company, and we can put that up to establish a prima facie case. And then it is up to that company to come forward with their actual costs or suffer consequences as a result. So I think that change in the law will prove incredibly useful going forward. I think the other is the issue of supply. And in my view, at least, the essential facility doctrine can relate to IP rights and also your active pharmaceutical ingredients. The essential facility doctrine does relate to an infrastructure or resource, but a resource is very broadly defined. It can be any asset. And so the assets around IP rights, know-how are critical in this case and can be invoked. And that may be a superior approach to something like a refusal to supply, where there is an element of having to look at exclusionary conduct rather than just simple access. And again, I think the constitutional rights could be read into that provision as well. So let me stop there and allow our last speaker to respond before we have a debate.
Yes, James, thank you very much. A number of important points that you've raised there. I couldn't help but feel this whole question of what the return is has always been, certainly as the person who's written the various excessive pricing judgments, I've always found that very, very difficult. And the easier it is, I think Babalegi actually now does help a hell of a lot on that front. But having said that, you raise a second point, which has really vexed me, which is this question of jurisdiction. And I'm really worried about that because, you know, I regard that judgment in the Banks case is probably the most progressive judgment we ever gave. But I'm conscious about it being an outlier, and I'm conscious about, you know, what the boundaries are. And maybe in relation to this issue, we might want to chat about that too in our discussion. Because I'm such an idiot when it comes to technology, I do apologize that I should have reminded the audience. I do that now. Please submit any questions you have to the Q&A line. And if so, I shall certainly pose this to our panelists. And I think our last panelist is Greg Harman. Greg, welcome. And again, thank you for participating in our South African debates as you've done on numerous previous occasions. The floor is yours.
Okay, thank you very much. You know, I thank all of the other panelists as well. It's been a really interesting set of views. You know, what I would like to talk about, I think, specifically is around the pricing of vaccines, and perhaps to do that from a big pharma perspective. I mean, clearly there's been a lot of debate, not only in South Africa, but globally. And of course, from I guess when we're thinking about pricing, and not only pricing, but potentially supply, from a policy perspective, the concern is that the companies can use their dominant power to price excessively in markets where demand is inelastic and where there is insufficient competition. And the reality is, in this market, in the drugs market specifically, is that consumers are likely to pay high sums of money for access to life-saving drugs, putting to one side whether that's immoral or particularly fair. And I'm not going to jump into that debate. So in this session, I'm going to provide a couple of general comments on pricing, perhaps not getting into the broader welfare or policy debates. And I probably stress that the views are not necessarily my own, but they're to produce more debate. So it's important to start, I think, with a discussion as to what an excessive price is. You know, one can't simply observe a price is high and conclude that it's excessive. The test is not simply whether more drugs would be purchased if a lower price was offered. I mean, that would, kind of apply to pretty much any products in society. Now, in general, if goods and services are not regulated, then companies have a freedom to set prices. However, new drugs usually have a period of patent protection, which obviously may diminish effective competition. And of course, many countries have regulations that govern how prices are set during that period. Unfortunately, those regulations are not uniform, and we observe a very wide range of regulatory mechanisms. In other markets, competitive pressures should ensure prices are not abusive and kind of absent market failures, I suspect. However, where a firm has a dominant position, there is a chance, of course, that the firm could increase prices above the competitive prices, due to the level of reduced rivalry in that market. And for that reason and others, competition law is there to safeguard consumers and to reduce exploitative behaviors. And of course, the Competition Act in South Africa, as amended by the Competition Amendment Act, prohibits firms from charging excessive price to the detriment of consumers or customers. Now, determining whether a price is excessive requires that the alleged excessive price is higher than the competitive price, and whether such a difference is unreasonable. And the Act in 8.3 sets out a range of measures that might help determine if a price is excessive. So, whether the respondent's price is above cost, a so-called cost price margin, whether the prices that are observed in South Africa are higher to similar products either in South Africa or in other jurisdictions. And of course, there are other parts of 8.3, but I think it's also relevant that it notes the structural characteristics of the relevant market are important. And I think in excessive pricing cases, and especially here, a key question is whether the respondent should be able to earn a return above a normal return due to its own commercial efficiency, or given the risk and investment that it's undertaken, or whether actually it's had state support in some way. So, from this, it would be, a reasonable starting approach, I guess, to assess whether a price is excessive, is to compare prices of similar products. And noting here, in relation to the vaccine, there has been a number of successful vaccines, which to some extent must compete with each other and must have some pressures on pricing, one would imagine. In the UK, through the case precedent, competitive prices has been kind of refined as prices that might emerge under conditions of workable competition. That's not really defined, but I think what it means is that we don't have to assume that competition is perfect competition, and that other forms of competition may well be relevant. And that may, in the UK, if there was a duopoly, as has been discussed today, whether that is a form of workable competition. So I've been following this quite a lot, and I have been following prices that have been charged in different countries and the price of different vaccines. And one observes that there is quite a large difference, not only by geography, but also there is quite a considerable range of prices for the different vaccines. So in the US, vaccines of the different from the different companies range from something like $4 to almost $20, and in the UK between $3.50 to almost $15. So that's quite a range. That's quite a lot of prices out there. And I understand that potentially the South African price per dose was above some of these ranges. So does that suggest that the price in South Africa was excessive by reference to these prices? Unfortunately, it's not really possible to reach that conclusion at this high level, because the devil is always in the detail. So for example, these prices would need to be adjusted because some of the difference will relate to how the drugs have been funded in different jurisdictions. The Pfizer price was lower in the EU because Germany contributed to the development cost. Of course, I think there is a policy question as to whether government funding should reduce the global price or just the price of funding in a particular country. Of course, also the spread of the pricing might reflect a degree of nationalism. Was Pfizer ever going to need to worry about the US government purchasing from China or Russia? And was the UK willingness to purchase the vaccine at an inflated price to secure demand, maybe to cover up from some of the errors that it had made earlier on during the pandemic? And of course, I think those types of factors might reduce the degree of true competition. Now, as a patent drug, as I said, most countries regulate prices, and those regulations differ significantly. And due to that, in the UK at least, the Competition Appeals Tribunal has placed less weight on such evidence, i.e. it reflects that those regulated prices might not reflect the outcomes in competitive markets. And I think the other problem with such comparisons is that it would be wrong to treat the vaccines as the same. They're not homogeneous, and certain demand side factors are going to justify pricing differences. One might, suspect that there is a difference between the quality of the various vaccines, and of course, there is concerns as to how good the drugs are. Again, that could well drive differences in prices. So from this high level, it's not clear whether there has been sufficient rivalry or not. There may have been, and whether the prices reflect workable competition. I suspect there's been some competition, but is it actually competition that we would expect under other kind of longer term definitions of competitive equilibriums? So, if it's believed that competition has not constrained prices, how should prices actually be assessed or regulated? And as James was mentioning, one such method is to determine how prices might be set through some definition of economic cost. And essentially, other regulated utilities, for example, use this type of pricing to set prices. So under this framework, a price may reflect the direct costs of manufacturing, including a share of common costs, the recovery of R&D and licensing fees and fees of that nature, and an allowance for profit. And each of these, whilst it seems relatively simple, there is a debate as to what level each of these should be. Perhaps the direct costs of manufacturing are easier. But as Dennis indicated, an allowance for profit is a difficult place, because whilst there is a notion of normal profit that can be calculated using finance theory, in competitive markets, we observe companies able to earn above a normal profit level for specific advantages that accrue to that firm. So the theory is easy, but the practice is more complex. And I think perhaps one of the biggest areas of this complexity is the risk associated with undermining investments in new drug R&D, the so-called chilling of investment. If this risk is underestimated, it can obviously lead to type 1 errors in excessive pricing cases. And it can't be denied, I think, that a great deal of risk in investments, there is a great deal of risk in investing in these types of vaccines. Firms have, in this case, invested large sums of shareholder money, and the risk of losing that money has been real. So Sanofi failed to produce an effective vaccine. Moderna was apparently pursuing multiple vaccine projects at the same time and raised over $1 billion of equity to fund the projects. If none of those vaccines worked, it would have been a disaster for that firm in particular, especially given it was relatively new to the market. Now, competition law allows firms to be able to return earnings related to the risks they take. But obviously, there's a question as to how do you balance risks and returns in this type of situation. And I guess one of the issues there is that we might observe the costs of one company being successful in producing a drug. But that's an ex post event. Ex ante, there was a risk that the company would fail in production, or it would cost more money than expected. And I think Big Pharma do argue that kind of risk of failure, the so-called fair bet principle, should be included in the valuation. And that, obviously increases the complexity. Now, of course, if companies were actually funded by governments, in line with, the kind of Section 8.3, then I think that would be relevant. And obviously, that would impact how prices were determined. But I think the other, so I saw this recently actually, and I think it's quite interesting. And again, it links back to what James was saying about potentially how prices are set by reference to the value extending somebody's life. But in this situation, there's another element, I think, that could be overlooked, because one might say, well, if I say yes, that is one side of the equation, right? But there could be an argument that the pricing of vaccines should be based on the benefit that you generate in total, which obviously includes the cost of hospitalization, medical care, and other effects. But in the case of COVID-19, it could also include the cost of lockdown, right? And the cost that society would avoid by purchasing the drugs. And if that approach was adopted, then the economic value of the drug from a government perspective would likely be in the thousands of dollars range, and potentially even more. And so from that perspective, one might argue that the pharmaceutical companies have exercised some kind of restraint, which may bring it down to kind of outcomes that we might expect under workable competition. So in conclusion, from a policy perspective, I think there's always a tension between the need to regulate prices, which could, if done wrong, lead to a chilling of investment, or seeking wider benefits through competitive processes. With respect to COVID-19, competition has emerged, and it's obviously had a positive impact, not only on consumer welfare, but also on potentially the finances of governments more generally. So if the counterfactual to this would be regulation, applying standard approaches, if that was the solution, I'm not sure that this would have resulted in lower pricing outcomes once all the relevant risks and costs are included. And as I said, unfortunately, observing the prices of the vaccine is insufficient to answer these questions. And so in conclusion, before one can actually conclude that there is an excessive pricing problem, I think one would need to do a more detailed analysis of costs and risks, because as always, the devil is in the detail in these things. Okay, that's me.
Good. Thank you, Greg. I've already got a question for you, but I'm not going to, from the audience, may I invite you to continue? I will read the question out, but I'm going to ask, because we've been going for quite some time and everybody's had their chance, whether anybody would like to respond to anybody else at this point. So Fatima, let me ask you whether there's anything you'd like to respond to directly. And then I'm going to also ask you, whilst you do that, the extent to which this question of access, which is so vital to the developing world, to what extent does competition law have a role there? Or is this an intellectual property type TRIPS scenario, or some other form of initiative that is required to unlock the problem? And what role, because we're at a competition conference, does competition law have? But I'm not going to constrain you just to that question. You may want to respond to broader issues.
Thanks, Dennis, and to the fellow panelists. So I think it has everything to do with it, because in the absence of a reset on the intellectual property regime and the successful use of the flexibilities embedded in the TRIPS agreement and the delay with the waiver discussions and the political configuration of obstacles, our only recourse actually as health medicine campaigners or as activists or as lawyers or as the CDC or the WHO is our competition authorities. Because I think what we are witnessing is a grave injustice in the way in which antitrust is actually playing out. So a lot of the conduct is anti-competitive, not just in relation to secrecy and non-transparency, but the way in which the monopolies are continuing to exist, the way they will exist for the next few years. I mean, you've seen the reports about the amount of profit that has been extracted and the overnight billionaires. So and it's a conversation we've had a lot with the officials at the Competition Commission. I mean, we've gone to them, I think, in the past year on like multiple issues to say, you, at the moment, as a regulator, you are the only ones that can step into that regulatory gap, because there is actually no oversight of the way in which these pharmaceutical companies are doing multiple things not just the licensing, not just the pricing, but a range of what we would call very negative conduct that then has a direct impact on access. So the first thing I wanted to respond to, Dennis, and I think that's where the role of the regulator is important. And I think in South Africa, we're lucky. I mean, we could bring the Hazeltown case and actually have that examination of whether the pricing of essential life-saving ARVs for GSK and Boehringer Ingelheim was set at the correct level with a reasonable rate of return, with certain due recognition for any innovation aspects that the pharmaceutical company may have contributed to. But you can't have private power, and I think goes to the earlier conversation you were having in the morning, where the private sector and the private pharmaceutical companies who are unelected, who just have their CEOs and their boards, they determine alone without scrutiny the rate of return. And you're right, Dennis, we would have loved for Hazeltown. I mean, I was the lead attorney in that case. And our legal team and our activist clients and healthcare workers and trade unions would have loved for that case to have gone to the competition tribunal and then the appeal court. But when it came to disclosure of the details of the pricing, this argument that we have every right to charge what we think we should, and that we can determine the rate of return, that is when the case was settled. And for us, it was, do we push for compulsory license, or do we push for a judgment? It will take a few more years and deal with the jurisdictional issues that James is dealing, or do we get immediate access of ARVs with multiple licenses for people in the whole of Africa? Because remember, we used that case, Dennis, to argue for the settlement terms, whether the licenses would benefit sub-Saharan Africa. It wasn't just for South Africa. So I think the interrogation of a reasonable return, I think, is important. And then the second quick response, Dennis, is that there's a myth about innovation. We can bring the evidence and data that this idea that the pharmaceutical companies alone have innovated on life-saving interventions, particularly on these vaccines, we can disprove that. And so there has to be a reckoning of what is the genuine innovation that you need to be rewarded for. And let's deal with, the intersection with our patent regime. We don't have pre-grant opposition in South Africa because the patent amendment bill hasn't been passed. So we can only challenge the patent after. And so the question of how are we rewarding innovation through setting any price, any reasonable return, and giving you the patent, I think that needs some examination. And maybe
can I just stop you? Can I just stop you there? And can I just stop you there? I'm sorry because of time. But I wanted to ask you this. I understand that everything you're saying. My question is whether you're asking the competition authorities to do that, which quite frankly, the WTO, through its inability to deal better with trade agreements and TRIPS in particular, and the kind of almost unfettered power that intellectual property has in this world, you're asking a national competition authority like ours, with great respect, under-resourced in the grand scheme of things. I mean, a damn good commission from the point of view of our resources in South Africa. Let me not be misconstrued, but it's a massive ask for them to, as it were, fill the gap in when what is really at root here is the exploitation of the intellectual property regime.
Yeah, I think they've done it before. They've done it in the past year, and I think it's possible. But I think you're right, Dennis. I think it needs political leadership. I think that there is something where, and Dr. Andari can speak to this, but there's been a reluctance by African leaders while pursuing the waiver, which is great and symbolic, and there's a lot of PR around that, to actually use the measures that are available to it, that is given to it in terms of TRIPS or in terms of domestic competition.
I've often wondered about that. Good point. Yeah. And perhaps that's a convenient way for me to ask you, Dr. Andari, to what extent that is not true, the point that Fatima has just made, this almost extraordinary inability to push the measures that we've got in terms of TRIPS, and indeed perhaps greater pressure. Are we not relying too much on the competition authority and in fact taking our eye off the fundamental ball, which is the exploitation through intellectual property, which, and I'll come to Greg's point now, you may want to deal with that too, the argument that, well, actually the pharmaceutical companies are at greater risk than perhaps those of us who think that the state plays a bigger role think. So please, I'd be interested in your responses.
Thank you, Judge Davis. I think it's not an issue of lack of instruments at the national level or sub-regional level. It is, in my interpretation, and I think colleagues in the panel have alluded to this, that in South Africa, you have this extraordinary situation that you actually have the expertise and the support to be able to use these instruments. What we see in many countries is the lack of national expertise, for example, to implement some of the tools that we're talking about in terms of finding out what a value of a product is and how to adjust that for pricing. Many countries do not have this expertise for putting it into play and enforcement, the economic justifications for cost. Many jurisdictions do not have the kind of competence you're talking about around the Commission. So whilst it's important that you note that there is failure at the global level to reach effective administration of intellectual property arrangements, much of the hurdles, as I see it, is actually at the national and subnational level. The ability to implement these measures. If you look at how many countries have actually price control measures out there, there are not that many. It's because of the complexity of implementing those measures. That, in my view, is really what is limiting any progress and any substantial progress in using these tools. Thank you.
But can I just ask you, just press you on this? I mean, surely there's a global problem here. I mean, the developing world gets the short straw every time on everything. And is there not a time where leaders get together and actually do something about it? I mean, is this not a political question that we seem to elide over and basically lump all the responsibility on under-resourced authorities within the national state?
There is obviously an opportunity here for concerted efforts. We talk about the African scenario. The African Union and the Commission is an opportunity to be able to bring down some of these measures. We talk about localizing production. We talk about ensuring that there is good distribution and close to health systems production of some of these tools. We've seen some movement very late-ish, obviously, around this pandemic in countries wanting to go collective through organized procurement, pool procurement. It is just not an issue of markets from a financial point of view in terms of control. It is also getting organized in terms of procurement strategies. As I indicated at the opening of my remarks, Sub-Saharan Africa is a very small market compared to the rest of the world, less than 5%. So that market needs to organize itself so that it's very, very efficient. Efficient in terms of market intelligence, and we're talking about some of that here, irrespective of the non-transparency you see in price offers. But in terms of coordinating available funding in the first instance, and of course, coming to the table for procurement in the most efficient way. It can be done. We're starting to see it happen through the small island countries, but more needs to be done. And you're right, Judge Davis, that it needs to have political muscle. It can't just happen. Thank you.
Okay, I'll come back to you. James, I wanted to ask you about, sort of, I'm trying to puzzle this all out. I mean, when, and again, I'm sure Fatima and you will, and well, all four of you will correct me, but I'm talking from a point of view of somewhat ignorant, which I shouldn't be, because I've done so many interviews about COVID-19 that if I could have a hot breakfast for that, I'd be wealthy. What I'm asking is, I mean, for a long time, it seemed to me we could only kind of do the final add-on through Aspen in South Africa, and that was the J&J one. But I mean, if you take, for example, say Pfizer or Moderna, who basically refused to have anything to do with us, so I understand, I mean, we have no jurisdiction over them.
Well, I think you put your finger on the biggest problem, Dennis, which is, it's common for us in the digital market realm to talk of power beyond just market power in narrow market and almost a broader economic and global power base. And I think we face exactly that same problem with the big pharmaceutical companies. And so to be almost the question of why don't we invoke compulsory licensing? Well, what was our concern as a commission if we interfered in negotiations over vaccines with government is that, do we end up with a refusal to supply South Africa, and are we blamed for that? If you have no manufacturing capability, how can you, in a sense, operationalize compulsory licensing? Now, the TRIPS was recently changed to allow for exporting, but again, there's probably one country, India, with a strong generics industry. So the balance of power, I think, is lopsided in this case. And that is part of the problem, because where is the global coordination to maybe exercise the right to get supply? That we don't have a sort of means to enforce in other countries. And as we saw, even when we take this patent waiver to the WTO, countries whose interests align with the pharmaceutical companies like Germany or Switzerland are not willing to support those, and it's a consensus-based organization. So that ultimately you are alone in those fights. You can't invoke some global jurisdiction, and no global entity can help enforce that. So I think that's fundamentally the problem, and that's why there is this imbalance. So we can take some fights as a competition authority, and no doubt we will. And maybe it's useful to take it out of the political domain and put it in an independent institution. But enforcing that, so we are told routinely that probably there isn't the capacity locally to manufacture the APIs, etc. We get a small offer like the Aspen one, but as Fatima rightly said, we're not seeing the supply coming out of that. We're low down the sort of priority list. And as long as we're denied the ability to produce the active pharmaceutical ingredient, we can never expand supply because we're dependent on them. So I think it is a fundamental problem in big pharma that we've got to learn from this COVID pandemic and address.
But then can I just ask you this, Jane, just help me here. So you guys will launch a case, let's say, about excessive pricing. I mean, presumably that's targeted against the various pharmaceutical companies. So what happens if Pfizer and Moderna in particular, even Johnson & Johnson for that matter, say, well, thank you very much, Mr. Hodge, but go away, because quite frankly, you have no jurisdiction over us, and so we won't supply you. If you want to, if Judge Davis or his successor are sufficiently insane to basically do what they did in Babalegi, well, then, we'll just not supply you. What do we do then?
Well, that's what I'm saying is fundamental to this power imbalance at the moment.
I want you to help me here.
And so, look, I think the one thing we have to do, which we've identified, is you have to build domestic manufacturing capacity.
I agree.
That becomes almost critical, because unless you can actually take that know-how and replicate it, then you're stuck. I think we do need to build some sort of global arrangements around this that can actually enforce against companies in the global jurisdiction. We've seen that time and again, as I mentioned earlier, in trying to take other pharmaceutical cases forward. We just get blocked with jurisdiction, and the countries don't help, and there's no way to enforce that. So that is something else we need to look at. And I think the other is a coalition of developing countries. We've often been helped out by India because they've been able to direct some generic production to us, and they have more capabilities. So those would be some of the potential solutions. I mean, I do think it's probably easier to get to a point of excessive pricing than maybe Greg suggests. I think whenever we've dug into these, the margins are just so vast that there's not even a debate around some fine calculation of whether 30% or 35% is, for instance, the correct return. You're typically talking thousands of percent. So I think that hurdle is not a big one to get over. And I think Babalechi also taught us we can invoke some simpler rules sometimes to get to good decisions. And that would be an innovation in competition law to ensure we don't get bogged down in fine debates for a very long period of time and can quickly come to some decisions. But
yes, I think
it is enforcing it.
Yeah, I mean, I accept the point that I think that, you know, the temporary dominance, the idea that you go through a pandemic and they may not be dominant if COVID went, I mean, if COVID went away, we wouldn't need the vaccine, just to take a hypothetical. Unfortunately, it seems hypothetical. But I suppose the point is, how are we going to run? I'm just curious from a competition point of view. I would imagine, and I'm going to ask Greg this from the other side, that if one gets a case like this, the pharmaceutical companies, if they litigate, will roll in like hundreds of experts who will tell us all sorts of fancy calculations about innovation. You don't seem to understand that we have 5,000 drugs and only one succeeds, and therefore the return isn't as high as that. I mean, this is going to be quite a complicated maneuver, I assume, one way or the other. Or are there precedents, other parts of the world, which are going to help us here?
Well, I think it is right that Big Pharma will roll in the experts, and they will.
I'm sure you'll be there.
Well, to be honest, I'm working with the Competition and Markets Authority currently.
Oh, okay.
Against a number of pharmaceutical firms. So, I mean, look, each case is specific. In those cases, you know, we're dealing with a generic drug, which I think is different from a patented one. And they will, right? And, you know, my point is, I would say, and going to James's point, is that there are examples, I'm sure, that the cost plus margins will be in the thousands of percent. And if that's the case, then bringing an abusive a case, you know, potentially is more possible. And I guess the question there, and you know, we saw this on Sasol, you know, one will have to determine whether many of these kind of these kind of theories are kind of stretching the bounds. I mean, I think that, you know, competition authorities have their arms around what is a reasonable set of you know, cost estimates. You know, people will know that, you know, we need to have regard to replacement values, and, you know, for a patented drug, you're going to have to include some allowance for R&D, because if companies don't get R&D recovered, then their incentives are reduced. I mean, that's just a fact. How shared costs are allocated. And yes, I mean, the company could argue that, you know, COVID drugs should have every single level of overhead allocated, but you know, there is a question there as to whether that is reasonable or not. So I think the jurisdiction point that James raises aside, as to whether you can get some of this information, I think that there will be cost data that will allow you to determine what the economic cost is. There then will be a question as to how big the margin is above price. And I think it's then a matter for the courts to determine at what level above a normal level of profit something becomes abusive. And
yeah, I mean, I think that's right, Greg. But I mean, that was the failure in Sasol from the Commission's point of view. Because had they told me that when I asked, I mean, what was fatal to that case was when I asked, well, what do you think the rate is above any normal rate? And they said, we all agree it's between 12 to 14%. No judge in their right mind is going to actually say that's excessive, just not. It may be higher than competitive, but since we never have a competitive market, you have to take that into account. I mean, we don't have a perfect market, but in this case, there are those who suggest that these rates of return are very significant. Can I ask a blunt question? Do you think that the pharmaceutical companies will defend this, or just simply say, go away, you're a piddly little developing country and we have no interest in?
I mean, that is obviously a potential outcome. I mean, there are other drugs out there, so there are some competitive pressures, right. Clearly. Yeah, I don't know. I mean, I don't know is the answer as to how they would react.
All right, I have a question for you, Greg, which comes from Lindy, and I'll read it out as it is on the chat line. A question to Greg Harman. I find it puzzling that you note that you won't comment on the morality or ethics on whether markets can ask any price they wish for life-saving drugs. Approximately 7,000 people are dying daily from COVID, and most of these deaths could be prevented by vaccines that were developed by public money. Could you please provide comment on this and how the markets and profits could remedy the problem?
Yeah, I mean, that's an interesting question. It wasn't that I won't comment on it. It's just that I wasn't going to comment on it in my discussion, because I think it opens up, a different box of issues, obviously. I mean, I think the problem is who is best to have the responsibility, the morality responsibility. Should it be private companies or should it be governments and other institutions at the end of the day? I think Pharma would argue that if they're a listed company, they need to earn a return to be able to pay shareholders. If the profitability fell, shareholders could well walk, and they have an opportunity to invest their money in other investments at the end of the day, which could obviously lead to a spiral of diminishing finance, which would impact future investment and so on and so forth. For me, the morality question, and that's not to say that drug companies do just price whatever they want. Obviously, at some point, demand will fall away, and I'm sure that they do have responsibilities and they do have a view on morality themselves. Otherwise, I would imagine that pharmaceutical companies could be much more profitable than they currently are. And if you actually look at the portfolio of drugs of many pharma companies, you don't see them earning excessive profits overall, and then you have all sorts of issues about portfolio size and everything else. But for me, I think that it's better to have a regulatory regime for patented drugs that sets prices at a reasonable level at the end of the day. I think that's the nature of the patent protection. That's what happens in the UK. The NHS buys its branded patented drugs through the regulatory framework, which caps the returns that regulated companies can earn whilst they're on patent protection. The companies then have an opportunity, if they don't want to deal with that, to genericize the drug, and that opens up the market for the benefits of generic competition, which hopefully would drive prices down towards cost. Yeah, would be the normal thing.
Thank you. There's much I can debate with you, but I want to also just move on to some of the other questions. James, the question is put here: talk us through the balance between successful and unsuccessful R&D in excessive pricing assessment of essential medicine. To what extent can the cost of unsuccessful R&D and other drugs be considered for recoupment in the marketing of successful drugs by charging higher prices during the patent period for the successful drug? I think you muted.
So you raised this point as well about Pharma coming with the 5,000 unsuccessful.
Yeah, I'm interested in your reaction just because of the question. Yeah.
Look, I think it is an interesting question, and I think Greg just raised the sort of portfolio issue as well. Should we take into account across all the portfolios? So what we're seeing let's take outside of the vaccine, in things like cancer, there's lines of research where multiple drugs are developed. And I would imagine a narrower view on that. And if you had to look at R&D more broadly, it would be on that narrower line of research. The fact that the company has multiple portfolios, I think one can distinguish that. I mean, maybe just to also highlight a couple of other things. I do think, this issue of R&D as well brings up the global question, because there is recoupment globally on R&D. Now, maybe there's a simple answer sometimes around when there is licensing, there's a flat percentage fee on top of any manufacturing cost that you might exercise. But I do think it is right that, and moral, that in fact the R&D is unevenly placed So I mentioned earlier the differential in pricing that you've seen with vaccines. You have a high income country price, middle income country, and low middle income, and we unfortunately always end up in the middle income, despite the vast inequality and the majority of our people not being in fact in that category. But that aside,
discriminated. Yeah.
But that aside, there is in fact economic theory that suggests when you have a fixed cost, which an R&D cost is, because once you've done the R&D, there's no incremental cost, it's only manufacturing, that there may be beneficial price discrimination where those with the lowest ability to pay or willingness to pay are charged less than those who have a much higher ability to pay. And so some form of discrimination that we've already seen emerging in pharmaceutical pricing can be, in a sense, institutionalized, and maybe developing countries shouldn't be accounting for a lot of the R&D costs that are occurred. And that difference in ability to pay is, in fact, precisely not only economically rational, but moral. I think the other thing, just to pick up, Dennis, is, we've also seen a few situations in COVID where drugs that were developed for other purposes have suddenly been responsive to COVID, especially hospitalization. And to take this sort of, Babalehi type reasoning as well, I mean, the sales then, are going to be far in excess of what the proposed rewards or even.
You're not talking about ivermectin, I hope.
No, we're not going to.
Because my dog is very upset about that.
But there are 3 drugs already that the WHO has identified as effective in hospitalization.
Yes, there are,
and there will be more. But to take the same example, these are drugs developed for another purpose. There was an incentive to do it and maybe return on that. Now the return is going to be far excessive to that, because they must have seen this rapid growth in demand. And this will be ongoing. So for those, one would imagine the initial R&D may have justified their initial price, even if we make that presumption in their favor. But the price, once you've had an explosion in demand, must be lower. And if it doesn't come down, there should be a cause for action there.
I take
so there are ways of simply dealing with this as well.
Yeah. I wanted to ask. Sorry, Greg. Sorry, I interrupted you, please.
Sorry, I was just going to say something else in addition to that may or may not be relevant. I mean, if you're thinking about, and I guess this is a distinction between a company's actual costs and the costs that may emerge in some form of competition, workable competition, and everything else. Generally speaking, you might think of failure as a sunk cost, and in effective competition, you might assume that you can't recover those fixed costs. Right. So actually what you might be, putting forward when you think about including failure is some kind of almost inefficient entry into the marketplace. Now, that's not going to be right for all drugs and everything else, but in some cases, I'm sure that will be a relevant consideration.
Yeah. Now, I wanted to ask, following from that, Dr. Ndari, there are a couple of questions here which kind of maybe I should ask you, because they go, it seems to me, to this governance question. And one of them, which is asked, is, COVID vaccines have created 9 new billionaires with a combined wealth greater than the cost of vaccinating the world's poorest countries, coming from an Oxfam report. I'm just interested, again, isn't this I keep on looking at this and saying, fine, but that's like a problem. It's a massive problem for me, but it's not one that a competition authority can deal with. But it is one that seems to me global governance is really at the root of. I don't know if he's missing, because I haven't got his. All right, Fatima, perhaps you want to answer that in the absence of Dr. Ndari.
Thanks. So I'm gonna change course a bit, because I think there's, we're having this long conversation about cost examination and what's a reasonable cost and reasonable rate of return. And I think where we're coming from is that life-saving intervention shouldn't even be patented. You shouldn't be given an exclusive patent monopoly for 20, 30, 40, 50 years on medicines. And I think
but with respect, that's not going to happen. That's not going to happen without a complete revolution in governance.
No, but it wasn't always like this, Dennis. I mean, this was in the last 20 years when Pfizer had a particular role in the TRIPS agreement to basically commodify life-saving interventions like medicines. I mean, medicines were not always commodified and they weren't always given these excessive patent protections. It goes also to the heart of what is happening with our patent regimes and our systems, not just in Africa, but elsewhere in the world, to examine the claims that are being made by certain people seeking patents. Take Moderna, for example. Moderna is saying we're not enforcing patents in a pandemic. We won't sell to South Africa. They haven't delivered a single vaccine to a low-income country. They've now announced that they may set up a plant, but it's not their patent. It's not their innovation alone. The NIH, US government owns jointly with Moderna that vaccine. It's not their vaccine alone. Yet they have got a patent in South Africa.
But with respect, that means you have to pressurize the government.
Yes.
Oh God, you've gone.
So, hello?
Back. Sorry, yeah, you froze for a moment, but that's a governmental question.
Yeah, and so I think it goes to your opening remarks about the systemic and structural issues about how can you enforce, an appropriate pro-constitution, pro-human rights competition law, competition act, and based on the Mediclinic judgment as well about the recognition of what is a public good, when you have an IP system and regime in the world that is so regressive.
Sorry, you froze again. Sorry, you've been freezing, Fatima, maybe just for me, but
I think whenever we talk about patents and IP, then
I agree. They close it down. But because I'm running out of time, Dr. Ndari, I see you back. Can I ask you again of this particular problem before we? It may well be that it's my thing that's freezing. I'm sorry. Thank you, James. Which makes my life difficult, James. Dr. Ndari, can I just ask you about this question of the global? We keep on coming back to that. We keep on coming back to the fact that there's been a monumental failure of global governance here. And a lot of the questions that have been put to me have been about the fact that that basic medicines should not be, they're essential items.
Sorry, Judge, you froze at the point there and I missed part of what you were saying. But
I'm talking about the global governance question. I'm so sorry. My link is poor. The global governance question. And the question is, we keep on coming back to this, and the question of the fact that essential medicines are not there to be subjected to profit.
I think the panel here has very well addressed the issue of profits and accessibilities of profits. And what, again, is a jurisdictional issue. The pricing, the way it is going, very difficult to get a handle of that at the global level. Critically important that there is visibility of what the companies are charging across various health systems. We are very far from that. The lack of transparency was seen by member states as being one of the major reasons precluding the drive down to uniform affordable prices. We continue to advocate that indeed the essential medicines and health products should not be commoditized. Very quickly to address part of the element that James raised about, and I think Greg to some extent was dealing with, how all of a sudden you can get a repurposed medicine continuing to draw very high pricing in the pandemic. The argument that we see is that companies are having to put in place new facilities to be able to cope with the expansion of the requirements, but that should be easier to determine insofar as what percentage of cost that would be. But again, I think we see it as unjustifiable to continue to exploit the initial high prices that were in place for the small markets of the original intent for the products. Again, the failure is that we see globally is because there isn't sufficient common information to everyone. There is insufficient willingness to disclose R&D costs, both from governments and private entities. And there is obviously bilateral agreements being reached between governments and private sector entities for which there is not a way to actually see what the price offers are being made. There are a lot of discounting measures in place, again, that remain very, very opaque across the regions. And this is really making it difficult to be able to communicate price information sufficiently clearly to support reduction in pricing.
Thank you. I'm running out of time. I was going to ask you, Greg, just on that point. If an excessive pricing case was run, would it be particularly difficult if I was sitting there as a judge to say, how do I quantify what, for example, is the money that's put in by the state in order to diminish the risk as opposed to what's put in from the private sector, which increases their risk?
Yeah, I mean, it has to have some effect, right? In terms of, I guess it depends on the nature of that support. If the nature of that support is in effect funding for the development of the vaccine, then essentially what you are saying is that the government is taking some of the shareholder risk away, right?
Yeah.
I mean, it's now a lender to the business, if you like. And so I think that you could use financial theory to kind of work out the overall return that would be needed in the way in which you would address the cost of capital in any way. You would have one set of funders, which is shareholder. They're still exposed to the risk and they have a required rate of return. In a sense, what you would be saying is that the government would lend effectively at a lower rate if it was willing, if the government was willing itself to, write off the debt if the investment turned out to be unsuccessful. So I think there are financial mechanisms that would allow you to do that. So at the limit, if there was 100% financing, then you would say there should be no, well, you might even argue that there should be no return above profits, but obviously governments also have alternative investments that they make. So some kind of social return, government return may be appropriate.
Well, thank you. I have run out of time because that's really 10 to 1. I know we started late, but I did indicate that we tried to finish by 1:45. We've gone on. Let me just say this by way of conclusion, in thanking all of you for what is an absolutely fascinating debate. I hope this was recorded because I'd like to play this to my students in relation to dealing with these particular questions. And just a couple of observations from my side. I mean, there's obviously this huge challenge of national competition authorities running these cases, perhaps on 2 points. One is the technical one, which we've just ended with, which is, determining what the price would be, which itself is not always that easy. But I take James Hodge's point that I think that the amendments to the legislation, which came up in 2018, 2019, are going to make it more difficult for, if it were the defendant, if the defendant is the pharmaceutical company, because of the fact that there's going to be a shift in at least the burden of proof, or at least an evidential burden. Which does make it more difficult. In fact, one would be interrogating that slightly more carefully than perhaps one had done previously, which raises the point. But it does raise the further competition point, which is, of course, is a jurisdictional question, which for obvious reasons I'm obsessed by, but I think James Hodge has raised that too, and I think it's an important one to raise. And then there are the broader points that have been raised with regard to, what governments are doing generally, what Africa is doing, what global governance is doing, and in a sense, the role of intellectual property. And I think the point made both by Clive Ondari and Fatima Assam in relation to the way in which the existing trips. Perhaps we're not exploiting the exemptions, but there's no doubt about it that in the light of COVID, as an inflection point in the world, these are issues that need to be debated. And frankly, I know, Fatima, you've probably got more persuasive voice than I have, but the truth is governments have more than all of us put together. And if the whole of the African continent would actually just start shouting in a uniform voice on this, that might too be helpful. But all of those questions, of course, are food for thought, which we can't pursue any further. I want to thank all four of you for being great sports, putting up with my abuse and questions and sharing your expertise with us. Mpumi, it's back to you.
Oh, thank you, Judge. That was absolutely fantastic, especially in that it almost mirrored where we started today, which was thinking about that Pan-African ideal, a kind of continental unity that could be used as the bridge and a lever to push back to power in the time that it takes to build our local manufacturing capacity. And I think that one of the hearts of this debate that is really, it goes at why it's so live, is the fact that we are not talking about widgets. We're not talking about, some little gadget that goes into something else. We are talking life-saving drugs. And insofar as we allow these excessive pricings to continue, we have accepted a society that allocates these life-saving goods on a basis of wealth. And we're okay with the fact that the poor get sick and die and the rich get sick and survive. And I don't know, I think Mediclinic is a welcome avenue for us to think more about that and whether we're okay with a society that looks like that. So on that note, I'm going to give us a 10-minute stretch break. We were scheduled to start our next academic sessions at 1 o'clock. We are moving that out just a little bit to allow us all to attend to our comforts. And we will start our academic sessions, I think, at 1:10. Just an indication of how it's going to work this time. Remember last time there were 2 Zoom meetings. That's not the case this time. This time we have academic session 2A taking place in this Zoom room. So no movement required. You can stay right here. And academic 2B goes on to a Teams link, which has been placed in the chat room. If you just scroll up, I know there's been a lot of chatter in the chat room, which we welcome and we love. Perhaps our organizers can just repost the Teams link. Furthermore, I know some of you have been emailed a Teams link. If you have trouble accessing that, please do pop it in the chats. And just a reminder, when we go back into our academic sessions, it's much easier for moderators to search for questions if they're actually in the Q&A chat box, as opposed to the chat. Because as you can see with the chat, it gets lost a little bit. And we want to make sure that we capture all your brilliant questions. So make sure in the Q&A section is where you pop your questions. I hope to see you I will be attending academic session 2B. Hope to see you there. The topic for 2B is the role of public interest in recovery, including SMEs, transformation, and other social goals. And 2A has to do with lessons from the pandemic enforcement for economic recovery enforcement. So very much continuing the live debates that we've been having this afternoon. Thank you so much for joining us. We hope to see you in 10 minutes. Enjoy your stretch break.